We're watering like crazy. Chloe! Oh.
Hello.
Yes. How are you, love?
Good, how are you?
Doing well. Just popped on.
Did you just get on?
Yeah, literally like 30 seconds ago.
Oh my God.
No, you're good.
This is Angie, and I think, correct me if I'm wrong, but would you call yourself a very well-informed person on everything Bree, Santos, and 2K?
Pretty much, yeah. I'm a social worker. Well, retired now. But I found them back in was it August or September of when this all first happened. And I was fascinated the fact that a young man was fighting for and filing for custody of a child that young. That's rare. We don't see that very often. I was enamored by it. And then I just kind of started watching it. And then misinformation was going out by the court docs because they can be confusing. And I worked in the court field at the time. And I just started putting out the correct information, and here we are.
So the reason I requested you is because I was given information, but I have not, actually I should have just gone and done some research, but I was in the, I was live.
Yeah.
So maybe you can help clarify it. But before we get into that, can we get to 1.2 million likes if you want the latest with Bree Olson, 2K, and Santos? We'll get to it. Let's try to get to 1.2 million likes. Also, repost and share so that we get more people here. Everybody repost and share. We're going to talk some Bree, Santos, and 2K right now.
Yeah.
As soon as we get to 1.2 million. Repost, share, and like. Trying to get, as soon as we get to 1.2 million, we'll start the tea. The tea will be spilled.
Love it.
Everybody tap, trying to get to 1.2 million. As soon as we get to
pressure.
that.
Now I hope I have it. I hope we have what he wants.
I'm sure you do. Yeah, we did it. And Ren reached level 2. All right. So it could be incorrect information, but my chat told me that Bree Olson, who is a streamer that many people know here, currently allegedly having a child with Santos, who's also another known streamer here. Apparently, Bree Olson filed some emergency court request for custody. Is that true?
Well, I'm actually, like I said, I just hopped on. I'm actually just getting ready to read the court docs.
Oh, okay. Let's do doubles, but then we'll get to it.
Yeah.
Doubles. Doubles for the next 20 seconds. I've got a 7-win streak. Let's keep it up.
Perez, you need this. Look at this fan. You guys, I didn't even notice this is my fan. It even has a cold
Thank you,
button.
Brandy. We got 10 more seconds. Oh no, they came in hot.
Thank you, love. Thank you,
Carrie.
guys.
Thank you, Landria. Thank you, everybody.
Hey, Brittany.
We can still do this.
Katie. Thank you guys so much.
Save it.
So sweet.
Actually, you know what? If anybody has a glove, drop it ASAP.
He knows what he's doing.
Because I want to get to the tea.
I don't.
Oh, Santos is here.
Oh, Santos is my biggest fan. He doesn't miss hi Santos. He doesn't miss anything. Him and Bree have to come over here to be able to listen so they know what the hell is going on because they're clueless if I wasn't here to help them.
Everybody drop. I want to be Angie. Let's go. We got another 20 seconds.
Wants to beat me. Dang, Perez.
Come on. I want to keep up my streak. Pretty please.
Hold on,
we got another 10 seconds. Go. We got another. Thank you, Orlandria. Thank you, Donnie.
There you go. I'm looking Perez out.
Come on. Fudge. It's going to be tough.
I'm blowing up. All right, guys, let's go.
So you haven't read the documents yet?
I have not. I never read them beforehand, before I come on. But I also was given information that there is some really private information in there, and so I do I'm very cautious and careful. I never release any dates. I never release any medical stuff, and so I'm hoping that other people don't have it up posted with all that information because I haven't even. Thank you, love. I haven't even seen it yet.
Reading it all might take a long time.
There wasn't too much. Actually, let me pull it up. Hold on. I think there was only like 10, 11 pages. I've read every single document of their court case. I'm actually going to start for people that are like just joining in, I'm actually going to start going backwards and start from the beginning and read it so everybody is all caught up to date. Not right now.
How long do you think that'll take you?
I mean, I'll do it like spread out, but like I'll probably do it over a week. I'm going to Hawaii next week for a week's vacation. So when I get back, I'll probably do
No,
it
I
then.
mean to read the latest one.
Oh, the latest one?
Only because I have to hop off. It might take you like a while, and I have to leave because I'm getting a haircut. So I've only got 17 minutes left.
Oh yeah, it will take me long. Well, when you get back from your haircut, can you come back on?
Yeah, I mean, yeah. If
Yeah,
you're
because
still
it's
beyond, it might be a long time from now.
yeah, it's only it's 11 pages. Um,
Yeah, that
so
might
it'll
take
take
you a bit. Yeah,
yeah,
like
it'll
probably like
take me a
20 minutes
little
or something.
yeah, it'll take me probably 30 minutes or whatever, and then answering questions in between. And again, like I said, I don't. Oh, and then there's another one that's 7 pages. And again, I
Wait, there's
skip
two
over.
things?
Yeah, I skip over a lot of the. If there's any dates, medical stuff, any of that stuff,
Okay.
I will definitely skip over
But
that.
I definitely want to connect
93
with
pages. Oh wait, hold on. There's one that's 93. Let me double check my email and see. I have several emails. Like I said, I have not even looked.
you
Let
guys.
me go to
If
this
you
one.
have a glove, drop it at 30 so that I can not lose. Drop the glove at 30. All right,
They're
I'll
trying
go
to
look at it
distract me
too.
so I lose.
Drop the glove at 30. Drop the glove at 30. Oh, we dropped the hammer. Okay.
Knocking me out. I just did my hair. Calm down,
Drop
guys.
the glove at
Jeez.
30.
Just kidding. Yeah, it will be put up on YT as well. But yeah, when you come back, or even tomorrow, like if you want to hop on, then
Yes,
I can help
exactly.
it.
I was about to
I
say
can
that.
explain.
If I don't see you tonight, we can talk tomorrow.
Yeah, because I'm PST as well, like you, and so I usually come on at like 6:30 our time.
I'll be on at 4 tomorrow, but I'll probably be on by till 6. Okay, Sierra dropped a glove. Let's go.
Don't
We
let her
got
be
30
embarrassed.
seconds to come from behind.
Thank you.
Everybody. Oh,
Thank
thank you, Hardaway
you.
Haven. Oh, we got an
Let's
extra
go.
10
Oh
seconds.
my
Let's
gosh,
go,
it's so
Karen. Let's go.
scary.
Let's go. We
Oh
gotta
my
keep up the
god.
streak.
Go, go,
Let's
go,
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 everybody. Thank you, Tennessee.
go.
Thank you, Karen.
Oh
Yes.
my gosh. 21
We got
seconds. Oh
another
my
10
gosh, let's go.
seconds.
Oh no.
Oh,
Oh
yes,
no, he's
Karen.
coming
Yes,
back.
Rainy. Yes, Karen.
No.
Yes,
Let's
too. Oh, thank you, everybody. Thank you, Karen.
Ah, what is
Oh
that?
no, oh no, oh no,
Thank you,
oh
love. Oh
no,
my god, that
oh
was so
no, we got,
beautiful.
oh
Thank
no. Oh, can
you.
we
Go,
do this?
go,
We got
go.
6
Oh my
seconds.
god,
Oh,
hurry. Oh
fudge.
my god,
We
I was
got 3
wondering.
seconds. Oh, it's all
Thank
good. Thank you,
you.
Sierra.
What
Oh, it
is
was so
that? Thank
close.
you. Oh my gosh, love. Thank you so much, you guys.
It's all good. Thank
You
you,
guys
everybody.
are
Let me
so
thank everybody.
sweet. Let me thank them real fast.
Thank you so much,
Thank you.
Sierra. And in
this.
addition to number 1 VIP Sierra, Daffy Dale, Tennessee Christie, or Orlandria, Karen, Rainy Day
Oh, this is so
Colors,
cool.
Justice, Carrie, Maddie Noel, Mandy, and Ask Santos. Appreciate you all. I'm only kidding. Santos did not gift me.
Thank you, Kita. Rhonda, you got a glove and a bunker. And Katie, you got a lightning bolt and a bunker thing. And thank you, Taz and Danita and Katrina, Erica Love, Double to
Wait,
Travel, Honey to you, and Pup Mom. Thank you guys so much.
is Santos still in here? Tell her, it's probably Bree, to go live ASAP because I only have 13 minutes, but we can cover a lot of ground in 13 minutes. Tell them to go live ASAP. Well, if I don't chat with you tonight, let's chat tomorrow, okay?
Yeah, absolutely. Yeah, just request me whenever. I don't know how to request people. I just come on here and push the button. So I don't know how to request people. But if you see me, just request me. I'll accept you.
All right, sounds
All
good.
right. Have a good night.
Bye.
Have fun with your hair. Thank you guys so much. You guys, that is so sweet. I so appreciate you guys. Okay. Perfect timing. Okay, Jess, you said that there was one that was 93 pages. I don't have that one. Do you have that to me? No, I haven't seen anyone's comments. At least I'm ready. Are you ready? Let me see. Hold on. Where did Jess go? Breeze is 93. Yeah, I don't have that. I only have right now John's docs. Let me check my okay, hold on. Oh, I don't know. Hold on. Let me check my emails in here. Hold on. John's docs. Let me check my okay, hold on. Oh, I don't know. Hold on. Let me check my emails in here. Hold on. Hold on. JK, I had it. I just didn't go down far enough. Yeah, so I'm going to start by saying this. So it's 93 documents. We'll be here for a while. I'm not going to, typically I would have someone come up and help. Thank you, Sammy. Sammy, always make sure I have the documents. I just didn't scroll down far enough. Typically I would have somebody come up and help, but I've heard that there's a bunch of medical stuff in here. And so, wait, you still can't hear me? And so I'm going to read by myself just because I want to make sure that I'm skipping over any information that needs to be put out. I really hope and pray. Listen, I love the T-pages. Okay, the T-pages help me do what it is I do. But I truly hope that any information that's put out, I hope any personalized information has been redacted. I haven't been on. I haven't seen, so I don't know. I'm not accusing. I don't want anyone to think I'm accusing. I'm not accusing. Okay? I'm just saying. I just think it's very important that, you know, Baby W has them personally. I've just heard information in regards to what has been put out. Okay. I need white eyes. My eyes are burning like crazy. We finally have really nice weather. So me and the Grands have been outside for 2 days playing. And my eyes are driving me insane. Okay. Let me open this. It's that's set. Oh, wait a minute. Wait, what's happening? Oh, God. Oh, God, Sammy. Sammy. Open file name? No, not copy file name. Oh, God, Sammy, it's not opening. What do I do? It makes me sad that you guys even already know what it is. Why would she do that? Sammy, the one... Oh, I had to send it as a zip file. Oh, Sammy, I need your help. Hold on. I don't know. Oh, you have to extract it. Sammy. What does that mean and how do I do it? I don't know how to do that. Sammy. Help me, love. I'm so lost. I don't know what to do. I just noticed that it said that. Yeah, I don't know how to do it. Listen, I be struggling. At least I keep it real. I keep it real that I don't know what the fuck I'm doing. Right? And that if it wasn't for y'all, hi, Mama Deb, I would be so screwed. Oh, right click unzip. Right click on this document, this one. Okay, it brings me to this page. So what do I do here? Wait. Okay, so oh wait. You have to extract the zip file. Oh God, these are big words. I did that. I clicked that and it only says a sound. Should I hit this button? Oh, yeah, let me download it, right? Okay, hold on. Look at me pushing buttons. What happened? Now, where do I find it if it's downloaded? Oh, there's 3 dots. What does the 3 dots say? Oh, open new tab or details. But I think it downloaded. Where would I find it if it's downloaded? Oh, my files? Where's my files at? Listen, I'm smarter than a lot of things. This just isn't one of them, okay? Give me a break. Where do I find... Oh, files right here. Hold on. Hold on. Today. Open. Let's see. I love it, you guys. You guys are helping me. Oh, wait. What's happening? Am I pushing it too much? Yeah, about that. Okay, so I'm pushing the button. Wait, hold on. I'm pushing this file, right? That's download. And it's not letting me do anything. Like when I because I'm supposed to push this one now, right? It's in the files under downloads. Wait. What? Oh, downloads? Okay. Oh, zip. It says zip. Hold on. Maybe this is it. What the fuck is happening? Sorry. Didn't mean to say that. I did it, you guys. Thank you guys so much. Oh my gosh, you guys are the best. I would be screwed without you guys. Round of applause for all of us. Listen, team effort, okay? Team freaking effort. We did it. I love us. Okay, let's see. Now, mind you, I have not read this first, so there is going to be pauses and all the good stuff. Okay. Boop, boop, ba-doop. Let's see, what does it say? Okay, petitioner John, respondent Bree. Request for change temporary emergency orders of child custody. Court hearing 2-6-832C. Child custody, I request temporary emergency orders. Has all the child's information, I won't least. B, the orders I request child custody as follows. One, it says John to schedule. Okay, again, you guys, I'm gonna have to redact a lot of this stuff because, again, I'm not releasing any medical information, doctor's appointments, anything. For those of you guys who are just joining, I'm reading the new court docs that just came out today where Bree filed for emergency custody of baby W. It's a lot of documentation. There's 93 pages on this one. There's 11 on another one. There's 7 on another one. But again, I will not release any medical documentation. I'm going to skip around it. Okay. So she's requesting that John schedule some type of evaluation. I shall have immediate access to his daycare provider's records, daycare parent application, and in order for me to be listed as listed with the daycare as W's mother. I'm curious as to why, Bree. You're in California. Remember, you have nothing in Texas. Why would you need all that information? But nonetheless, let me shut up and read. John, excuse me. John shall be admonished for prohibiting me from accessing these records and the parent application, as well as for doing same at W's pediatric office. Number 3, in order that any new medical, dental, vision, health, mental health, daycare, school provider for W shall have me listed as W's mom, and a note that I am to have full access of these records and any parent application online portal used by any of these facilities immediately upon W's enrollment as a patient/student of these facilities. Number 4, in order for John not to misrepresent the court's orders as to my access to W's records and or the ability to be around W to any of W's providers, and in order to ensure John provides these facilities as a copy of the 8/27/25 order. And number 5, John shall confer with me on OFW before making major decisions for W. Where all this came from, I literally have no idea. And if you guys, when I'm reading these guys, I'm not ignoring you. I don't want you guys to think that, but it's hard to go back and forth, and the writing's little, and it's a lot. So to keep us moving, I'm going to keep reading that. So if you guys, keep it, listen, let me just do a little quick disclaimer too. Keep it cute in the comments. It's okay to have a difference of opinion, right? But over here, we keep it cute or we mute. Okay. So mods, that's all. Okay. Number 2, this is a change from the current order of child custody. Number 1 of 2. The order for legal or physical custody was filed on 8/27/25. The court ordered John has temporary sole legal custody of W pursuant to the DVRO. I'm not asking the court to change this order. Due to John's behavior, I'm being forced to file Let me read that again. Due to John's behavior. Did I just say that? I'm not asking her to change this order. Due to John's behavior. It does say that. I wanted to double check and make sure I was reading this correctly. Due to John's behavior? What about your behavior? What is his behavior? Being a fabulous father? Shit, how dare you? Don't do that. Anyways, due to John's behavior, I'm being forced to file an ex parte RFO to enforce the existing order, that I have access to all of W's records, as John is not following this order. And his attorney has confirmed in writing that he will not follow this order as to access to W's daycare parenting application, which is accessed only by John. Then number 3 is child support. There's nothing there. Nothing on 4, nothing on 5, nothing on 6. Number 7, other orders requested. An order allowing me to propound discovery to John/his counsels pertaining to the December 25 alleged police report. Counsel testified/discussed in length at the 1/6/26 hearing. She's requesting an order allowing me to propound discovery to John's counsel pertaining to the December 25 alleged police report. I don't know what that is. Okay. The next one, number 8. Time for service / time until hearing. And it's number B, the hearing date and service of the request of the order to be sooner. And then it says number C, the writing is very tiny. Help me. As an alternative to an ex parte ruling on my request, I request a hearing on shortened time. If this RFO is set on the court's regular calendar, I will have to wait another 2 to 3 months to have access to W's records and his daycare application, despite there already being an order for this. And John will continue to misrepresent the orders to facilitate like this is an interim. John will potentially continue to not schedule W's a service that somebody's requesting. Again, won't read. And has already done so since the referral was received. Oh my God. Okay, I'm not going to read what it's from, but this is what it says. It says, and has already done so since the referral was received on 1/23/26 from the pediatrician. That's been a week. You want him to jump through hoops? Fly through hoops? Are you shitting me? It's almost like when my son when they found out he had his brain tumor. You guys, look how long it took to get it. Anyways. Never mind. I'm just going to read. I'll explain. I'll break it all down as I go. And I will not have the evidence I need to dispute the counsel's testimony at the 1/6 hearing at the upcoming evidentiary hearing. Okay, number 9, facts to support. The orders I request are listed below. The facts I write in support and attached to this request cannot be longer than 10 pages unless the court gives permission. Please see attached declaration below. W's pediatrician, daycare provider, and early intervention services provider will not be explicitly named in this package as to protect the privacy of the providers due to John. Stop it. Due to John's supporters in the past emailing people involved in this case, such as the professional monitor company and parties used in the judge manner. And then I declare under penalty and perjury law that that's correct. All right. She does. All right, now we're getting into the written concept. And again, please forgive me if I have to kind of stop and bounce around a little bit, because again, I'm not going to read any of the documents. Okay. Respondent Brianna Lynn Olson's ex parte declaration. Attachment number 9. I, Brianna Lynn Olson, hereby declare as follows. I am the respondent in the above titled parentage action. I offer my declaration in lieu of personal testimony pursuant to 2009 and 2015.5 of the Code of Civil Procedures and Rule 1225 of the California Rules of Court. I offer this declaration in lieu of my personal testimony pursuant to Marriage of Stewart 1984, blah, 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 blah. Okay, number 1. Procedural background. Petitioner John Giese, hereinafter John, and I share one minor child together, W. This information. On 8/27/25, this court ordered that a 1-year restraining order after hearing naming me as the restrained party and John as the protected party. W was not listed as a protected party, nor did the court prevent me from having access to W's medical, school, daycare, provider, and extracurricular records. Attached hereto as Exhibit A is a true and correct copy of the RO after hearing, DV 130, filed 8/27/25. Pursuant to the 8/27/25 orders after hearing, John maintains sole legal and primary physical custody of W. I have unsupervised parenting time with W in Dallas, Texas, and its surrounding counties for up to 1 week per month. My fiance, Santos Salazar, here in Santos, is not to be physically present at my visits with W. Number 2. At the final DVRO hearing on 8/27/25, the court scheduled a 1/6/26 review hearing regarding something me for, there's just a T there, a random T there, so I'm trying to review hearing regarding, I don't know what it's supposed to be saying there. Something, me overcoming the FC 304 presumption. Attached hereto as Exhibit B is a true and correct copy of the 8/27/25 minute order noting the scheduling of this review hearing. At the 1/6/26 hearing, petitioner's counsel, Ms. Taylor Budnick, informed the court that she had just received a police report in the last few days from the San Antonio Police Department, which allegedly reported that during my Christmas week visitation with W, I took W to a home with unknown male strangers from my fiance's side of the family, and that I was not present with W at the house. Ms. Budnick has not presented me, thorough counsel, with a copy of this alleged report. Further, I am unable to request this report via propounding discovery to John and his counsel absent a court order pursuant to FC 6309. When my attorney told the court that this was the first she was hearing about this from Ms. Budnick, opposing counsel blamed not reaching out to my attorney about any of this on he having just received the report. Based on the testimony given by Ms. Budnick regarding this report and a video of me and my fiance arguing, neither were served to my attorney prior to the hearing. An evidentiary hearing regarding overcoming the 3044 presumptions was sent on 4/2/26. Attached hereto as Exhibit C is a true and correct copy of the court's 126 minute order noting the scheduling of the 4/2/26 evidentiary hearing. John did not testify about the report on Christmas break at all on 1/6/26. Colleen hit the nail on the head. I just happened to look up and see his comment. AKA, I need to see what you have so I know how to spin it and lie. Exactly, love. Perfect comment for me to pop my head up and see. Number 3. Request. I respectfully request the court to make the following ex parte orders. Boom. Hold on. W's evaluation. I'm not going to read that. And now she's requesting access to an evaluation of some sort. Daycare information. W's daycare in order for me to have immediate access to W's daycare provider records, the daycare parent application, and in order for me to be listed as his mother, John shall be admonished for her. How dare you? For prohibiting me from accessing these records and the parent application as well as his pediatrics office. Parental listing. In order that any new medical, dental, vision, mental health, daycare, school provider for W shall be listed or shall have me listed as W's mother, and a note that I have full access to his records and any parent application online portal used by any of these facilities immediately upon W's enrollment. Non-misrepresentation. In order for John to not misrepresent the court's order as to my access to W's records and or ability to be around W to any of W's providers, and in order to ensure John provides these facilities with a copy of the 82725 DVRO. E. Meet and confer. In order that John shall attempt to include me in major decisions he makes for W under the temporary sole legal custody orders by conferring with me on OFW. I'm sorry. I know I said I was going to pop in. He has full legal and physical custody. Typically when you have, let me turn my things off. Typically when you have full legal custody, you don't have to share that information. Thank you, love. So I'm confused on why she's requesting that, or did her attorney not explain that to you? Was there something put in there? I have no idea. But she does. Bree, you have no. I forgot to tell you, Bree. Get the circle mat out. Get the circle rug out. Crisscross applesauce. Listening ears on. Keep it quiet. Okay, and listen. Okay. F, discovery orders. An order allowing me to propound discovery to John, his counsel, pertaining to the December 2025 alleged police report pursuant to FC 60339. And number G, and an alternative in order shortening time. I am not going to read number 4 at all as it pertains to... I'm not going to read number 4 at all. It pertains to medical stuff that has to do with W. I won't read it. And again, thank you, Melissa. And again, I ensure, thank you guys. What the, thank you. I'm asking everyone else that reads these documents or post it, whatever, please don't put this stuff up. It's just... And I know it's already up and other people doing it. It's just not going to come from me. I'm going to keep my integrity intact. I know that I saw someone said that's up on Reddit. I do know that. I'm going to keep my integrity intact. And on my page, I only like information to come out that's true, correct, on the point, honest, and keeping everything that should be private, keep it private. So I get that a lot of you guys already know, but I'm going to keep it that way. Okay. Number 5, hold on. Okay, I can't read this either. She has some concern. C. Hugs! Thank you, love! Oh my god, that was so cool. Okay, let me see. Okay, again, number 5. Sorry, guys, I'm not going to read this either. This is all going into her thoughts and opinions on baby W and his milestones. What I will say is that she's trying to say that she noticed it way back at like 4 months, but she didn't address it until he was 1.5 years. Thank you, love. It says it's important to note that I started addressing my concerns in 7/27. Okay, so again, sorry, I'm not going to read all that. Okay, number 6. It should be noted that W had a... Okay, it should be noted that W had a 15-month checkup that John did inform me via OFW. At times throughout the OFW messages after W's 15-month checkup, I inadvertently conflict that the 15-month well visit with the 18-month well visit. In reality, John never told me when W's 18-month visit was to occur, nor did he provide me with such paperwork like he usually does immediately after all of W's appointments. Prior to finally getting access to W's file at the pediatrician's office recently, which I had to involve both attorneys in doing because John had falsely told the office I was not to have access to anything. I thought John had given me notice of all appointments, but was wrong. W has been to the pediatricians more times than John notified me of, including multiple appointments in which he had said his mom, he and his mom insisted W be seen for. Yeah, out of nowhere, all of a sudden, she's all of a sudden concerned and now wants to know what you've not been concerned or asked about this information this whole time prior. So all of a sudden now you want it. That's weird to me. But here we go. Kelly Jo. Okay, number 7. I provide the above contextualization because during... Sorry, I'm trying to also read ahead so I don't slip up. Because during my 12/22 to 12/8 visit with W, I noticed he was still something. The fact... Okay, so I'm not going to read any of that either. First of all, what she's even bitching about and complaining about is absolutely ridiculous. Absolutely. Mind you, Jordy and baby W are 1 month and a couple of days apart. Okay? She does the same thing. And the girl's smart as a whip. So I have no clue what her complaint is. Jordan knows all of her colors, her numbers, she knows her ABCs, she got her shapes. But anyways. Okay, number 8. On 1/7/26, I reached out to John after speaking with W's doctor and stated, hey, do you remember when W had his 18-month checkup? I erroneously stated 18-month checkup and meant 15-month checkup. And I asked if they had tested him for something. And you told me that they didn't see any signs that they needed to. Well, I called them today. Hold on. I called today and asked about more information, and they didn't test him for it. Okay, first of all, so again, this document is going to be a little bit more difficult to read than the others because I can't just read it, right? Because of the stuff that's put in here. And again, I'm going to keep it quiet. But you never, ever, ever had a concern, Brie, ever, about anything. At least you never addressed it. Let me not say you never had a concern. You never addressed it until some random in your comments made a statement one day. And as soon as said person made a comment about said disability, all of a sudden you have been riding the wave that that's what's going on. You're not even around your child enough to know. Howdy, cowboy. Thank you, love. You're not around your child enough to even know what's happening. And do you think maybe, just maybe, I don't know, just going out on a fucking limb here, maybe he's not communicating with you as much because he doesn't know who the hell you are. He's not comfortable around you. You're not around enough because let's not forget he's in Texas. And what? That's right. You don't have anything of importance in Texas. Your words, not mine. Okay? My grandbaby will talk up a storm when she's with me, mom, dad, brother. You get the whole family around, and all of a sudden she's like, blah, 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 blah. You see what I'm saying? So I don't know. You're legitimately grasping at straws. But the problem with doing so, Bree, is that you're doing it in court docs. So, and remember that wise information that you have, that every child is going to look for their mother one day. So you doing all of this is putting out information that eventually, when W comes to find you, this is what he's going to see. My mom thought I had this, and this. My mom wanted this. What? Not very smart. Not very smart. But anyways. Okay, so let me try to read this without saying. Okay. Okay, when I called them today and I asked about more information, why they didn't test him for it, because I have concerns. And they said, hold on. Much better now, I can see it. Okay. You have told them you filled out the form. Questions. If you had asked me, I would have expressed my concerns that I had. Anyways, are you able to take W for an appointment and have them check again or update his information? Again, I am going to keep reading. Do you not think, Bree, the people he's around all of the time would have a better idea as to where he's at, what he's doing, etc.? Oh, Tara Lake, you haven't missed too much. It's just really difficult to read because I'm not releasing the medical issue complaints. But basically, Bree's asking for access to all this stuff because she wants special testing done, whatever. So, okay, where was I at? You never told me you filled out the form, and you never asked me about any questions on that form. If you had asked me, I would have expressed my concerns that I had. Anyways, are you able to take W in for an appointment and have them check again or update his info because we need his pediatrician to refer for further testing? Okay. Listen, let me get through this day. This is pissing me off. So let me finish this, okay? She then puts some stats down and says, this could be from a lot of screen time or not being around other children, but it's definitely a huge concern. He's not, whatever. We need to get further testing done. Okay. So that's all I'm going to read on that one. And I'll move on to number 9. But let me say this. You don't typically have to ask at a pediatrician's office to have special testing done, right? You go in and they ask how many words do they speak? Do they respond to their names? Do they respond, like if they fall and they scrape their knee? Do they cry? Do they, whatever? Do they make eye contact? They ask all of these questions. You don't have to go in and say, hey, blah, 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 blah. Now, if you notice things are going on, then yeah, bring it up. But you're not around really enough to know that. But anyways, all because of one comment. Somebody has planted something in her head, and it's her last straw that she has in hopes of, gotcha. You're wanting to put something on your son to be a gotcha moment to John. Like, let that sink in for a second, Bree. Hey, honey. Yes, here's my daughter coming in, Jordy's mom. Yes, they actually have a screening now. Hold on. At 18-month checkups, and there is no need to bring it up. Can we, first of all, my daughter, Jordan's mom, and a nurse. Okay, there you go. They actually have a screening now at 18 months checkup, and there is no need to request. Okay, but again, you're trying to pin something on your son because of a comment. That's crazy to me. All to be a ha-ha moment. Yes, thank you, love. All to be an aha moment to John. Stop it. Stop it. That's ridiculous. That's terrible. Okay, number 9. John's reply to me was unhelpful, sarcastically stating, why didn't you attend his 18-month appointment? Well, that's a great question. Thank you, Amy. Thank you, love. And why are you asking me about this just now? Great question. John tends to reply to my inquiries with sarcastic comments that imply you were not involved. Therefore, why should you have a substantive opinion about W? That's Chloe. I was just getting ready to ask you guys, and I look up at Chloe's like, how is that sarcastic? That's what I'm trying to figure out. Why weren't you there? And why are you just now bringing it up? I don't find that sarcastic at all. That's a legitimate question, Bree. Anyways, he also has a pattern of implying that I have only brought certain issues to his attention until it is too late, when in fact I have regularly been communicative with John about W's health since birth. Attached here to Exhibit E is a true and correct copy of the OFW messages from 1/7/26. Again, John never gave me notice of an 18-month visit. No, don't do that. Whatever just happened, calm down. Tried to ask me a question. Nor did he send me the paperwork afterwards, and this was the visit during which something was screened for. Wait a minute. Correct me if I'm wrong. Above, didn't I read that he was not screened for said thing she wanted him screened for? Didn't we say that? Yes. Okay, I just wanted to make sure. Now she says, again, John never gave me notice of the 18-month appointment, nor did he send me the paperwork afterwards. And this was the visit during which the screening was done. Brie, are you still in your circle? Crisscross applesauce? Because you need to have your listening ears on. This is how you learn things, love. We're just here to help you. We're just here to help. You need it. No, literally, she is foolish. Her doctor told her. That's crazy work. And again, just put him through it again. Just keep putting the kid through it. Eventually, maybe they'll find something so I have a leg up. No, that's crazy. That's horrible parenting. Anyways, John's comments are unfruitful and are never sent from a place of resolution. Oh, coming from her. I never took the position that W has, whatever, as I am not a medical professional. My position was that lack of early communication issues with children should prompt a parent to seek an evaluation. And it was done. Ha! You just said it. 3 lines up. You said it was done. Just because you don't like the answers doesn't mean it's not done, Brie. Listen. Number 10. I let John know that he did not tell me about W had an 18-month well visit and never sent me the paperwork afterwards, which is uncharacteristic of him. Okay, so then you're saying here, hi Izzy, you're saying here that he always provides you the documentation and keeps you informed of his appointments and what's going on. That's what you just said. It's uncharacteristic that he missed one appointment. God forbid he could have been busy. Shit, who knows? But he always does it according to you. So let's mental note this. When I pointed to this discrepancy, John sent me the 18-month well visit documents. The appointment occurred on such and such date, and I was only provided with the paperwork from that visit on 1/9/26, 3 months after it occurred. Okay, so you're a mother. You know that children at that age have 18-month checkups, right? Every 3 months, 6 months, 12 months, 18 months, etc. So you know he has one. Why did you wait 3 months after to request? Why is it his information or his job to just always just send it to you? You know what I'm saying? Like, why don't you ask for it? That's on you. That's on you, Bree. You have to ask, or you show up. You be there. You be a part of it. Quit putting everything on John. Attached hereto as Exhibit F is a true and correct copy of the OFW messages where John shared the 10, 28, 25, 18-month well visit with me. In this thread is where I specifically prompt John to make an appointment to access W for her concern, because it was only until then that I saw a questionnaire that he had filled out. So it's 10/18 is when she's requesting it. Let's rewind back, guys. What happened in October? We went into depths, great depths about this conversation, right? She got held up and Patty, I love. We went into great details when she brought that entire thing up. Somebody made a comment or asked about it, and she ran with it in October. This one kills me. Okay. In this thread is where I specifically prompt John to make an appointment to access W for her issue. I have to come up with a word to say for it, because it was only until thank you, Brookie. So we could prompt John to make an appointment to access his stuff. She saw a questionnaire that John filled out for W. This is the questionnaire that showed John showed, and I had differing opinions regarding W's early childhood development. For example, thank you so much. Thank you, Amy. You know I love a good little Amy makeout session mid-convo. Thank you, love. For example, he answered no to W having any health issues. Yet, well, this doesn't even make any sense. Again, I'm not gonna say it, but she was like, he said no, he doesn't have any issues with health issues in regards to communication, and then talks about thank you, love. You guys are spoiling me. Stop. And then goes on and talks about something completely different. It's almost like I have a stomach ache. My child has a really bad stomach ache, and I was wondering why you didn't check his ear. Happy birthday, Melanie! Everybody show Melanie some birthday love in the comments, please. Okay. But this is difficult trying to navigate through, but I will. Okay. And we don't need to know anything about that. Okay. I'm going to skip over all that. Okay. Number 11 on 1726 OFW thread attached as Exhibit E. I informed John that my concerns for her concern is only growing, as I had just seen W lesson 2 weeks ago, and he was still not doing what she thinks. What you think magically shit's just going to change in 2 weeks? And again, he doesn't know you. Anyways, I then asked John if he would be making an appointment to see if W needed any type of referrals. John did not answer my question. Well, because it was dumb. I then followed up with John about this on 1926. See Exhibit F. Number 12. When John did not answer on 1726, I reached out to W's pediatrician to see if they could directly provide the records of W's 18-month well visit to me. Recall, John had not provided me with the 18-month records until 2 days later. You got them. 2 days later, the same day, you got them. The doctor told me I was not allowed to have access to these records because they had a court order stating I was not allowed access. W was never a protected party under any version of the DVRO. There has never been an order for me not to have access to our son's records. Due to this representation, and John not providing me with the 18-month well visit notes directly, my attorney reached out to John's attorney to attempt to resolve this issue. Attached hereto as Exhibit G is a true and correct copy of the email dialogue between our attorneys that occurred on 1/8/26 regarding access to W's health records. I encourage the court to thoroughly review how Ms. Budnick discussed this issue with my attorney in these emails, as her position and overall demeanor about this topic was extremely concerning, to say the least. I know you lying. The entire dialogue was rather unfortunate. Ms. Budnick said that it was deplorable for me to accuse a 2-year-old something. It is. It is. So Bree, say then that I'm I don't know what to say. Again, the child and you don't really have a bond. Okay, you guys, I do not want any talk in chat about autism at all. Okay? Not saying it's good, but I only like correct information to come out of here. Okay, so I know other people are like, oh, well, my child has, and I'm sure that that's the comments. I know no one's doing it, viciously or deliberately or to be negative. I know that for a fact, but people will take and switch and twist things, and we only like correct information to come out. Oh, that's a good idea. I don't know how, though. Can somebody mute that? One of the mods, do you guys know how to do that? Because we don't want to say that. Thank you so much. Of course, Principal David. Thank you guys. I'd be screwed without him. Yeah, so we don't need to say that. We don't know that okay, I'm turning this off. Hold on. Yes, turn off. Okay. We're not putting anything on this child. The fact that she's trying to do it is crazy. So we're not going to do that. And again, whether the child has it or not, he's perfect just how he is. Thank you. Yeah, no, we don't want to speculate. This is all about just reading these documents and figuring out. Because if I wanted to talk about it, I would be saying it this whole time, right? So we're just going to, again, keep it cute. Love you guys. Okay. So Ms. Budnick stated that it is deplorable for me to accuse a 2-year-old of having delays. Ms. Budnick's statement only confirms that the only recourse I have is to file an ex parte motion on this issue. It is clear John, via his counsel, believes I am not privy to an opinion regarding W's health and well-being. Number 13. Of most concern is that John, by the way of his counsel, finds my opinion deplorable, when in reality, any parent would be concerned that their child, she feels, is delayed. Furthermore, Ms. Budnick's misrepresentation that this court has fully decided that I have not overcome my 3044 presumption. You haven't. When, in fact, this issue has yet to be decided until our April 26th hearing date, only solidifies the fact that my concerns will continue to fall on deaf ears without the court's intervention. John and his counsel have concluded that my differing opinion about W, about his delay, is not one to be considered and will never be considered. Such a conclusion is in fact a deplorable position to take. Now, Bree, I'm not sure what you want him to do. He took the child to his appointment. He got the screening done. You said that. You said he got the screening done. He didn't send it to you immediately right that second. And all of us, when we've taken our kids to their appointments, it's a little bit hectic. And when we leave, it's a little hectic. But he did send it to you 2 days later. You got the paperwork. You got the report from the doctor. You may not have liked the answer that was on there, but you got it. And the sad part is the fact that you didn't like the answer that was on there. That means to me, that shows to me, and I may be wrong, that you wanted him to have something wrong. That is sad and absolutely disrespectful. That's deplorable. That is what is deplorable in this entire situation, is the test said nothing was wrong and you're mad about it. Okay. Number 14. On 1/22/26, John confirmed he would not be taking W in to be assessed and would not discuss this with me any further, despite telling me the entire week prior I would follow up with his appointment. I was very frank with John and told him he was in denial. Stop it. John then said, well, you shouldn't have asked at all. I already said I wasn't going to discuss it until the pediatrician recommended it. I guess I'm confused on somebody who is with the child all of the time, and then you have somebody who's with the child short amount of time, right? She gets a week out of the month if she chooses to take it all. And again, it's a whole thing of he's uncomfortable with her. She get, like, they don't even know each other. Yeah, he's not going to be yapping like he does with his daddy and his grandma. Yeah, not even a full week. And now you just don't see him at all. I don't know. All right, number 15. The next day, 1/23/26, John and his mother, Jennifer, my BFF in my head, took W to his pediatrician for a reason. I attended via FaceTime and voiced my concerns regarding her issues to the pediatrician. John and Jennifer were visibly upset that I had once again voiced my concern and tried to say that W, he babbles. Every baby babbles. He's 20 months old. Babies babble. That's what they do. That's how they communicate at this age. The doctor agreed. That W did not babble at all during his appointment, and made a recommendation. Thank you. Okay. Again, I won't read all that, but it just says that the pediatrician said it's great to be proactive in children's early childhood education. Absolutely. I don't think anybody is disagreeing with that. Number 16, despite John's position via his counsel that perhaps W just isn't very comfortable around me. Oh, look, I didn't even know. And I rarely spend time with him. Correct. See Exhibit G for the below the belt. Wait, what? For this below the belt analysis about my relationship with W per opposing counsel. I have always wanted what is best for W's health and will continue to want what is best for him. I know our son and our son knows me. Any commentary to the contrary is not grounded in reality. Listen, lady, I am beyond grounded in reality. I have 4 children, 6 grandchildren, and have been a social worker for 30 years. Okay? As a first-time mom, I think it is important for you to do some research on what a child is supposed to do and where they're supposed to be at. Do some kids talk great at 20 months? Absolutely. Do others not? Absolutely. My grandbaby babbles all the time. And then there's other times where she'll be clear as day and put a couple words together. You're expecting him at 20 months to say, oh, hi, Mom. How are you today? Are you still with the dirtbag Santos that's not supposed to be around? You're going to take me around him again? My dad said that. What do you expect? He's 20 months old. What are you expecting him to do? And if, in fact, let's just go out on a limb, right, Brie? Are you still sitting here listening? Listening ears. Crisscross applesauce. Let's just go out on a limb and pretend that, in fact, he's not, thank you, fine, that he's having trouble talking. Is there a reason during that 1 week that you get to spend with him, you were on live the entire time? instead of having your ass sitting down on the floor with him, working with him? Why aren't you during that 1 week working with him? Why aren't you sitting there talking to him and trying to get him to sound out letters, right? Doing the whole phonics things. A, apple. Ah, B, ball. Bah, right? You have to do the whole thing. Don't come in here with this bullshit. Which, block your ass. I don't understand. Then at the end of the week, if you see a difference, then maybe say something. But you're also, I gotta do a puzzle. But you're not doing anything to work with them in the meantime. That's how kids learn. Is by them. By you guys communicating and talking with them. Let me finish reading. We're gonna be here forever. Okay, number 17. As of the date of signing this declaration, John has not contacted, this is redacted, to schedule an evaluation, despite having a recommendation from the referral. I attempted to follow up with John about this and provided the center's phone number directly to him. John only responded with, "I will call them. Have a good day." Okay. I have not received any updates. What's happening? What just happened? Okay. I have not received any updates since then on this appointment being made. Attached here too is Exhibit I, is a copy of the OFW messages to John on 1/28/26 regarding W's appointment needing to be scheduled with redacted. John's delay in making this appointment, combined with what can only be described as ominous at the thought of W, may have an issue. One that you were pushing on him. That's crazy. Necessitates an exparte order for John to schedule W's evaluation by close of business on 2/9. Number 18. Separate from the issues regarding W's evaluation, I was recently allowed access to W's medical records on or about 1/13/26 after the issue was resolved via counsel. After reviewing same, there are concerning patterns that hold on. Oh, okay. There are concerning patterns to show that John and his mother's apparent attempt to establish me as a neglectful mother. Such attempts include, but not limited to, a note in file that I am and a rug abuser, but denying denying cigarette usage around W, even though it is public knowledge at this point that John and his mother both smoke cigarettes at home. Are you comparing smoking cigarettes to rinking and rug use? I think there's a big difference between the two. I'm thinking there's a big difference between the two. Yeah, listen, that's okay. I mean, if that's the best you got, do you, boo, but the fuck? Okay, letter B. Doctor's appointments being scheduled within 24 hours after my visitation, weeks 11-22. Oh, I won't go into date, sorry. Doctor appointment being scheduled within the week after my visitation, and it lists the dates. 3/28/25, visit to doctor notes that Jennifer told the pediatrician that W was exposed to Rugsville in California with me, which prompted a rug test to poor W. The rug test came back negative. Do you want to know why, Bree? Why baby W had to go through that? You had that child at the MILF house. You guys, I'm not bringing anybody up right now. I gotta read through these documents. You had the child at the MILF house, and videos came out that there was rugs easily accessible laying around, okay, on a plate. You're telling me if you had baby W, if John had baby W out at a place there's 20 some adults around and there's rugs easily accessible, you wouldn't do the same? That has nothing to do with trying to pinpoint you as a bad mother. That was a bad mother. The police had to come and get the child from you. You guys had a 2-hour standoff. You cannot be serious. I don't think so, Cindy. I don't think she is okay. Like, that's the best you got. I'm legitimately confused on this. Yeah, I would have had him tested too. Absolutely, I sure would have. And yes, poor baby W. Poor baby W that you put him in that situation. Poor baby W that you took him out of the state that he was supposed to be in and you took him to California. Poor baby W that you put him up on a bed and for 24, 36 hours, whatever it was, you had him on live stream with people on that stupid TTS system screaming the most disgusting and vulgar shit at him while everybody around him is drinking and playing in the snow. Yes, poor baby W. I agree with you on that, but not the fact that he had to go to a doctor's appointment to make sure he's okay, because that is what a good parent does. A good parent does not take him to an orgy house and have the child propped up. All we have someone in the back going, oh, look how much money we've made. Oh, we're up to this amount of money. We've made money. That's disgusting behavior. That's deplorable behavior. You keep trying to talk about John having deplorable behavior. No, that's deplorable behavior. Anyways, sorry. Got upset. At the DVRO trial, when John tried to make the same assertion, the court said no evidence was presented that showed I had W around drugs, alcohol, or firearms. Well, there's plenty of videos to prove it. Number 19. The instinct to take W to the doctor after all of these visits is a concerning pattern that will only make W feel negatively about his time spent with me. Oh my God. Eventually, should this pattern continue, I worry that W will associate his time with me with urgent trips to the doctor. I also caught John lying to the pediatrician about past visits in the effort to make me look bad. You do just fine on your own. At an appointment on 10/25, he told the pediatrician that W had recently been at the ER for a serious illness following my parenting time, yet the ER visit was on 3/20. Anyways, and the ER records indicate what he was seen for. Further, to suggest to W's doctor that I have exposed W to drugs, causing W to be subjected to a drug test. Thank you! Thank you, Mom. Drug test at such a young age and vulnerable age is truly beyond the pale. The pattern that John has created in these records is wholly designed to paint me as a maniacal villain hell-bent on hurting my son. I mean, I think everything's been done so far is just justified. Exactly. I saw that victim card. I've told you guys from the beginning. My voice. She is going to continue to do what she can do to make sure that visitation is removed. She's lost child, so she can play victim. This is the perfect setup, knowing that the date is coming to. I did everything that I can do. It's all John's fault. Okay. Next one. Facts in support of access to daycare records and parenting app. Number 20. John notified me on 1/18/26 that W would be starting daycare the next morning. I originally brought up the idea of daycare to John on OFW in 6/25, inquiring if he was enrolling W due to comments he made online. Wait a minute. Hold on, I want to read that again. I originally brought up the idea of daycare to John on OFW in 6/25, inquiring if he was enrolling W. Nay! Thank you! Seahawks! Thank you, love. inquiring if he was enrolling W due to comments he made online. And he told me to kick rocks and never brought up the conversation again. Why are you watching him online all the time, though? Like, I guess I'm confused on on that piece of it. Thus, I was shocked to find out with less than a 24-hour notice that John had been working on this behind the scenes without even attempting to involve me. Again, let me remind you, Bree, you do not have any custody of baby W. You have visitation. You have no custody. None. Anyways, and let me also remind you, that's based on your actions. Your actions is what caused you to not have any visitation, any custody, only visitation. And then you went from having visitation for a whole week to 10 minutes. To 10 minutes. Thus, I was shocked to find out that less than 24-hour notice that John had been working on this behind the scenes without even attempting to involve me. I understand the temporary sole legal custody orders allow John to make unilateral decisions, sure do. But to not even attempt to talk to me about something as important as his first daycare placement illustrates he has zero interest in ever co-parenting with me. That's not what that means at all. First of all, why talk to you about it when it takes a long time to do it? You can be on a wait list for a daycare for months. Then they call you one day and say, you know what? Little Johnny just stopped going. We have a spot. Do you want the spot? He said, absolutely. I don't know if he did that. I don't know if this had happened, but this is how I'm playing out in my head. Absolutely, I'll take it. And then he let you know. He didn't even need to let you know. Be thankful he let you know. He may not have had weeks' notice to let you know. You go on a waiting list. They call, we got an opening, you want it? Yep, that's it. End of story. Nothing, you're trying to, just because you do everything with something in your mind to go against John doesn't mean that he does it the same way. So weird. Okay, I looked up the facility and saw they provided access to a live feed so you could watch your child. I asked John if the daycare provided that link. He said, I'm not giving anyone access to the link so I could protect W's privacy. Smart decision. Who would trust Bree or Santos with that link? You know, because they put everything out. They don't care. She'll be on live just showing baby W at daycare. No, that is an unsafe thing to do. Absolutely not. No. But I'm not the judge. I don't get to say no, but no. The answer is no. Yep. I then discovered that the live feed was connected to a parental application, and in order for me to set the application up, John needed to give me access. I told John that I wasn't just anyone waiting to see our child on the feed. John once again replied that he would only provide me updates from the school when he received them and make no mention of giving access of the application attached J. Number 21. After John's refusal, I called the daycare myself and was met with immediate hostility. Yeah, the daycare has to be cautious. You're just calling in, demanding access to the portal. They don't know who you are. I can only speculate as to why the daycare worker I spoke with began our conversation in such a volatile manner. Well, you can't assume it's because of John. You can't blame everything on John. You think John has a whole lot of power. However, the daycare worker did state she needed to reach out to the daycare's lawyer about providing me access to the records. This leads me to believe that misrepresentation was made about me not being able to have access to their records due to a court order, much like what W's pediatrician told me when I attempted to access medical records in January. Again, our operating orders make no mention of me not being able to have access to W's records. The fact that my access to W's records has been stopped twice in 1 month without there being an actual order in place only leads me to one conclusion. John is representing to these facilities that I am not allowed to have access at all. Yeah, I'm not sure she does have access, to be honest. I mean, I don't know. You have no custody at all, so you may not have access. Typically, that's how it goes. Be thankful he's giving you what he has. But I don't know if there's something on the side, that doesn't come out in public record that the judge said she can't have. I don't know. Number 22, my attorney also tried to call the daycare provider, as the worker I spoke with immediately said their lawyers needed to be involved. My attorney was met with the same hostility when she said she was my attorney. After my attorney's call to the daycare, she then reached out to John's counsel about the outcome of the call with the daycare. Ms. Budnick said that I cursed out the daycare provider and I put W's enrollment at that school in jeopardy. John also reached out to me on OFW to say, you need to stop calling places and acting ghetto. I absolutely did not curse out anyone on the call I made to the daycare. As soon as the daycare worker I spoke with heard my name, anything I had to say about wanting access to W's records was immediately shut down. Again, I can only speculate as to where this bias against me came from. However, I can say that this is not the first, nor certainly the last time someone has misrepresented the scope in which I am allowed to operate as W's mother. Attached is Exhibit K. Now, I will say this in regards to child cares. If one parent has custody, the other parent's not in the home, whatever. Typically, now it's been a long time since my kids are in childcare, but I have grandkids in childcare. Typically, they will ask, is there any court orders? If so, we need a copy on file. Your copy says, Bree, you have no custody. So yeah, they're making the right decision. Unless there's another thing that says you have no custody, but we're going to allow her this. That's how it goes. You have the legal custody is the part of the medical and the educational piece of it. You don't have that custody. Stop. You're the one causing the problems and making just random. Shut up. Number 23. You guys, my thing was over. You guys, 225,000 taps. You guys are freaking amazing. Thank you so much. Number 23, my attorney set up a joint email with Ms. Budnick, including to the daycare, so this matter could be resolved regarding my access to W's records. As of the date of this declaration, the school has still not provided me access, nor has John allowed me access to the parenting app, which could completely eliminate the element of having the daycare involved altogether. Ms. Budnick also outright stated in the email provided in Exhibit K that John will not provide me access when she knows there is no order to support this. I agree. To our complete shock, she also referred to assist my attorney in getting the daycare the correct orders. Hold on. Why does Ms. Budnick, why does my girl Taylor, why does she need to assist your attorney in providing the correct orders? Brie, why doesn't your attorney have them? If there is an order that has come out that says you can have access to this stuff, why does your attorney not have it? Why do you not have access to that? You should also have a copy of that order. You wouldn't need to go through all of this. You should have that. Okay, Ms. Budnick also outright stated in the email provided in Exhibit K that John will not provide me access when she knows there is no order to support this. To our complete shock, she also refused to assist my attorney in getting the daycare the correct orders. When we tried to inquire as to what she and her client told the daycare to make them believe I was not to have access to anything, she claimed the daycare was potentially a third-party witness. She said it was none of our business as to what they told him. Counsel's position was odd, to say the least, as one would think an attorney would want to ensure a provider as important as W's first daycare facility clearly understood the orders, but opposing counsel refused to participate in facilitating this. Based on the above, I respectfully request this court make an order to allow me immediate access to W's daycare record. Well, there's the answer right there, folks. There is no order that says she has access to it. She's requesting it now. She's requesting now. There's no order. That's why it wasn't done. You requested it, but you don't have custody. So there is none. So now, in this one, I respectfully request this court make an order to allow me immediate access to W's daycare records and the parental application. Y'all. All right, I'm going to read a few more. I'm going to take a quick break, go to the bathroom, and then come right back. But we're going to keep going. Number 24. There is a good cause to propound limited discovery pertaining to the alleged San Antonio Police Department report that Ms. Budnick testified to at 1/6/26, pursuant to FC 6309. Ms. Budnick testified extensively as to what this report said and when she allegedly received it. At one point, the court interrupted and reminded her that the court has no ability to enforce a subpoena on an out-of-state witness. Without that witness in court, i.e., the police, the report, which counsel was allowed to discuss extensively despite never sharing it with us, is completely hearsay. We want to issue very limited RPDs as to this report because it has unfortunately become a practice of John and his attorney to grossly misrepresent evidence, to my detriment, in the courtroom. And the video we watched on 1/6/26 was a perfect example of that. Similarly, as explained in my 1/5/26 supplemental declaration attached as Exhibit M, John completely lied to this court about one of the main instances the court based the finding of DV on. Across 2 days of testimony, John claimed he was scared, threatened, and harassed by Santos showing up outside his hotel in Anaheim on 6/20/25 and antagonizing him, which he claimed to be at my direction. This testimony came out of left field at trial, as this incident had not been included in any of John's declarations. Counsel never reached out to my attorney about this incident, and John never reached out to me about it. After trial, we found John and his friends live stream from the exact moment in question. They were not at the hotel, but at the airport, live streaming and laughing at their other friend, Chris, who was openly admitting he was luring Santos to the hotel while they all made fun of Santos. We suspect the police report Ms. Budnick claimed to have just received, leaving no time to discuss it with my attorney before sandbagging us with it at the hearing, had not been received, nor is it likely contain everything she said it contained. Oh, I'm going to finish up this page. Okay. Number 25, a request for discovery order will not place John in any further instances of trauma and violence, as this report allegedly has to do with me and W's whereabouts during my parenting time on 12/25/25. Of most concern is Ms. Budnick's testimony that she had just received the report in the last few days before the 1/6/26 hearing and was unable to share this report with my attorney because there was no opportunity to do so when she was out of town for the holidays. I do find that comment hard to believe, as Ms. Budnick regularly provides written notice written notice of her unavailability. Yet my attorney was not served with one during the time frame in which Ms. Budnick had no opportunity to share her report. As of the date of this declaration, Ms. Budnick has not provided this report to my attorney, and without a court order, I am unable to propound discovery on John, who is currently named as the protected party in an active DVRO against me. She proposed RPDs attached in Exhibit N. I declare under penalty and perjury of law of the state of California that foregoing is true and correct to the best of my knowledge. Bree. Wow, we still have a lot to go. Thank you, OC. Chloe, that's my question. Why is this an emergency order? Right, remember how she talked about how, oh my God, John's filing all these dumb emergency orders, blah, 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 blah. Pinky, thank you. That's crazy. No, yeah, her attorney absolutely did all of this. So we have a whole lot of exhibits to go over. So I'm going to pause really fast. I'm going to go and use the restroom, and then I'm going to come right back. So give me like 1-2 minutes max. I'll be right back. Yes, I will post this up on YT. Give me just one moment. Okay, I'm back. Heidi, level 13. I had to get me some throat lozenges. My throat is killing me. All this reading. Let me boom, boom. Yo, this really is blowing me away. Let me button this up before y'all got a surprise. What do you guys think? Question. What do you guys think about this? What do you guys think about her randomly out of nowhere requesting this information? She's not wanted anything. I think, my personal opinion, I think some of this is because she knows she's about to be screwed because she has not provided any of the documentation that has been requested. Now, I do also wonder, is he going to be able to go after her for sanctions like she did him for the $10,000? Because none of it is making sense to me. She has yet to hit on a point that actually will stand for something. Now, I'm not all the way through. There is a lot to go. This one document is 93 pages, and we're on page 17. Okay, so we have a lot to go. We're going to be here for a while. Oh, I have no idea if he went anywhere. I literally have not been on at all today, besides to post my videos and then popped on, so I have no idea. You guys are well. No, thank you guys. I so appreciate y'all just being here with me and hanging out, and I love the fact that everyone's in here. You guys all support me in the fact that I won't release a lot of information. A lot of people just want to know everything word for word, and I just don't do that, and I appreciate that from you guys. So, Thank you. All right, let's dive in. So Exhibit A is the DVRO, DV-130. It's just the original one. We've all seen it, right? And this is a terrible copy at that. So I won't go over all this. Just said it was granted. It expires 8/27/26. However, if she keeps this shit up, it very well may get extended again. Okay. Hearing. That's what the hearing. No firearms allowed. Let me go through. I am going to read this one. Number 12. Order to not abuse. You must not do the following things to the person in 1 and any person in 3. You must not harass, attack, strike, threaten, assault, schmexually or otherwise, hit, follow, stalk, last, destroy personal property, keep under surveillance, impersonate on the internet, electronically or otherwise, block movements, annoy by phone or other electronic means including repeatedly contact, or to disturb the peace. Disturb the peace means to destroy someone's mental and emotional calm. This can be done directly or indirectly, such as through somebody else. This can be done in any way, such as by phone, over text, or online. Disturbing the peace includes coercive control. Coercive control means a number of acts that unreasonably limit the free will and individual rights of any person protected by the restraining order. Example, including isolating them from friends, relatives, or other support, keeping them from food or basic needs, controlling or keeping track of them. Remember the keeping track of them? Remember when I was like, how did she know this? Like with whatever it was, I can't remember now, a ways up. I was like, I can't remember what it was now, but something I made sure to point it out again, that she was watching something that he had done. Okay. Controlling or keeping track of them, including their movements, contacts, actions, money, or access to services, and making them do something by force, threat, or intimidation, including threats based on actual or suspected immigration status. Coercive control includes reproduction coercive, meaning controlling someone's reproductive choice, such as using force, threat, or intimidation to pressure someone to be or not to be pregnant, and to control or interfere with somebody's contraceptive, birth control, pregnancy. Yes. That's what she's doing with Santos right now. She's using coercive control right now with Santos. Oh, you got that house? I don't want that house. Okay, well, delete us the fetus. Oh, you bought me that. Okay, never mind. I'll keep it. Oh, you want to go there? Never mind. I don't want to go there. Delete us the fetus. Okay, well then fine. You're going to buy me this, then fine, we'll do that. She's using coercive control on Santos right now. And then the no contact order except for OFW. They can have brief, peaceful contact, stay away order. Still got to do the parenting classes. That's going to happen. Is there anything else of importance in there? Service. Oh, no service needed because they were in court at the time. Okay. Let me go back up here real fast. Okay. Oh, this is this next one is. Oh, I'm getting there, Kelly. Yeah, I wanted to do hers first, and then I'm gonna read his response. I'll do an order. Any law enforcement. Oh, this is just enforcing the order. We've read all this, so the stuff that we've read, I'm not going to reread. This is child custody and visitation order. Okay, child custody, legal custody. The person that makes decisions about child's health care, education, and welfare. Sole to person one. That's John. John has sole custody, which is the person that does health care and education, Bree. That's John. He's the person in one. You're the person in two. Number two, or B, physical custody. This is the person that the child lives with. Oh, that's right. Sole to John. See, there's an option. It's like sole to person one, sole to person two, jointly, or other. Both of them are sole to him. He has sole legal and physical custody of the child. You have none. Okay, and then it goes on about the visits. We've all done all that. And then there's even an anti-protection or an anti-kidnapping order in place. It says there is a risk that person in two, which is Bree, might take the child without permission because she has violated or threatened to violate a custody or visitation order, has a history of taking the children without permission. Then it says the orders are granted as follows. Do not move without written permission of the other parent due to court. Turn in, do not apply for the passports, the travel information, all that good stuff. Okay, now we're on to Exhibit B. Exhibit B is natures of pursuit, proceedings are remove away order, request and restraining order filed in petitioner. What's the date on this? This is from August 27th to 25. Matters called to hearing. Petitioners are sworn in and testify. Petitioners, John, respondent, Zoe's Bree, okay? Petitioner request for DVRO is granted. The court orders a permanent DVRO for 1 year, restraining orders to expire 8/27/26. No client report was available for review. DVRO is signed and filed. Protected person and the restrained person were at the hearing, so no reason for proof of service. Petitioner is granted sole legal custody of the minor child. Petitioner is to have primary physical custody of the minor. Respondent is to have visitation with the minor child in Dallas and surrounding counties for the first month. Visits are up to 1 week long per month. Respondent's friend Santos is not to be present during the visits. Respondent is ordered to provide to petitioner the location where she will exercise visits. Respondent is ordered to take a 12-week parenting class and provide proof of completion. This was back in August. Mind you, she still has yet to take the parenting class. Counsels and parties are ordered to meet and confer regarding visitation. The court set the case for RFO custody visitation for January 6th. Notice is waived. Okay, Exhibit C. This is from January 6th. Nature of proceedings. Petitioner's request for orders for custody and visitation filed. These are the ones we haven't seen yet, I think. The following parties are present for the aforementioned proceedings. John, Brianna, the attorneys. The matter is called for hearing. LA Court Connect appearances by John Gacy, Taylor, Marie Budnick. The petitioner, respondent are sworn in and testify. The matter is set for evidentiary hearings as indicated below. Each party is ordered to exchange witness list, exhibit list, and exhibit by 3/16/26. The court indicates that this is not the court indicates that it will not consider any evidence not exchanged prior to the hearing. The RFO custody visitation is continued to April 2nd, 2026. The prior visitation orders are to remain in effect pending further orders. Respondent's fiance Santos is not to be present during visits except when held in Dallas. Then they changed it. Each party is ordered to take at least 12 parenting classes and provide proof of completion to the court. The parties are to meet and confer for FaceTime. I like how she turned this one in instead of the corrected one. Because remember, this came out at first and people were like, wait, what? And then it came out that they fixed it. About Santos not being there. Okay, D. This is Our Family Wizard messages. We're reading new court docs. Okay, so this one I believe I have to go backwards. Hold on. Yep, I got to go all the way to the bottom and then read up. Okay, here we go. So this is from John to Bree. We are at W's 15-month checkup. Bree, send me the visit notes, please. Thank you. John, he also has 2 back teeth coming in. Bree. She asked if there was a screening. He said they didn't because he's hitting all of his milestones. Bree, he's hitting all of his milestones. Why are you pushing something on him when he's hitting all of his milestones? Bree says, okay, I thought the same. The only thing I was worried about was he hits the side. What? Oh my God. Okay, I'm not reading that. She is trying to find any and everything that somebody on the spectrum does and trying to say, oh, I saw baby W do that. It's got to be it. No, that's not okay. Wow. Bree, that is, come on. Come on, stop it. Okay. Here's another OFW. This is from, this is on 1/7. This is from Bree to John. Hey, do you remember when W had his 18-month checkup and I asked if, anyways. So they was basically mean stuff. Well, I called them today and I asked about more information, why they didn't test him for it because I have concerns. And they said, you filled out a form at the appointment. You never told me you filled out a form. What do you think, Bray? What do you think that they do when you go to the doctor's appointments? You fill out forms. You update them on where they're at, what they're doing, what's happening, what's going on. Are they walking? Are they talking? Are they, whatever the case may be, how much are they eating in a day, what their weight is. You fill all that shit out every single time. So now he also needs to call you and tell you, oh, I filled out a form. Focus, Yanji, focus. Call them today and ask them about information, why they didn't test him. You filled out a form and never asked me. So you filled out the form, you didn't ask me the questions. How dare you, John? Damn you for filling out the form and not asking her. Even though you have custody, you have sole physical and legal custody. The child is around you 24/7, at least 21 days a month. Not around the mom, but around you. And you didn't call her and ask her questions for her input? Again, Bree, if you lived in Texas, remember, you don't have anything in Texas. Thank you, Tish. You have nothing in Texas of importance. Those are your words, not my words. But if you were there, you would be able to have this input. You know what I'm saying? You'd be able to be there, be around more often. You would know actually how your child is. But nonetheless, let me read. I would have expressed my concerns that I had. Anyways, are you able to take him in for an appointment and have them check again? Update his information because we need his pediatrician to refer him for testing. You are something else. I'm not going to read all this stuff. Does not respond to his name. Maybe to you. Maybe to you. He ignores you. Yo, we have all seen videos of him respond to his name. What are you? Listen, he doesn't know you. That's why. We're not trying to be rude and disrespectful. Not only that, do you know how amazing toddlers are at their ability to block you out? I can sit there and call Jordan, Jordy, George, Jordy. She'll be locked into whatever she's doing, and then she's like, and then answer, Kathy, see, hugs. Thank you, love. You are pushing something on your child so bad. It's actually really, really, really sad. It's very sad to me. Okay, let me see. And this where she says this could be from a lot of screen time or not being around other kids. Are you concerned? Okay, so that was what she said. He responded back, why didn't you attend his 18-month appointment? And why are you asking me about it just now? Good point, John. She says, we always agreed on me being on FaceTime during his appointments. And if I can't, you always send me the information afterwards, except for at his 18-month appointment. You left the part out that I just found out. And I actually brought up the concern the day that you gave me the information. You left at his 18-month appointment. So this is the first time you're hearing about it. I am even more concerned now because it is months later and anyways, my concerns only grow. I'm going to repeat myself very simply. Are you able, or basically, are you able, she's asking, do you take him to another appointment, do something else, test him again, blah, 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 blah. And then she says, don't be neglectful. Stop it. Stop it. F. Okay, so now this is John responding to Bree. Winter has met all of his milestones. He is perfect. Bree's not happy with that. Now, first of all, let me tell you, he sent that on 1/9. On 1/14, she responds. Remember how she was just bitching about how he doesn't get back to her lickety split, like get back to me? Why did it take you a day to get back to me? Well, she took a week. Almost. So she responds back, John, I spoke to W's pediatrician's office today. We would like for you to schedule him an appointment as soon as possible. Hold on. I just want to make sure I'm not reading anything crazy. Wow. She's basically saying, schedule an appointment, and me and you are going to be present at this, and we are going to go through this together, and he is going to get the testing that I want him to have. That's not how that works. The second form you sent me, I feel like the part you filled out was not accurate. How are you going to tell him when he's with him all the time? This is the piece that I'm confused about. He's with him all the time, not her. She's with him maybe 7 days a month. And let's not forget, Bree, you're choosing now not to be around him. Yeah, this I'm not going to go into because she does talk a lot about the different health stuff he has. I won't go into that. So please schedule his appointment with a pediatrician as soon as possible. Let me know the day so I can FaceTime him. We can update the doctor together on milestones. He's like, okay. And then she responds back, did you make his appointment? What day is it? He'll do a phone call. He says, nope, I haven't yet. And okay, 11 Central Time. Okay, what's this one? Exhibit G. This is emails. I got to go to the bottom. Oh, God. This is a lot. Oh, shit. Okay. So this is from Lindsay to Taylor. This is really a lot. Okay. Counsel, John stopped Brianna's access to W's medical record information. Before I reach out to the PEDS office myself, I wanted to talk to you about this first, since this would be most easily resolved by John making a call to the office himself. Brianna has called the PEDS office twice across the last 2 days to try to discuss what information John provided to the PEDS office about his 18-month appointment. I'm not going to the next one. First of all, let me say this really fast before I go into this. Bree, if you were regularly calling and getting updates on the doctor's office, from the doctor's office, not just this time, this is, according to you, this is the first time you're doing it, you probably wouldn't have the doctor's office wouldn't be so standoffish. Like, who is this lady out of nowhere calling at 18 months, at an 18-month checkup? Why didn't you call at his 9-month, his 12-month, his 15-month, 18, you know what I'm saying? Like, why aren't you calling for every other appointment? Why just this one? Blows my mind. I am, Dieters. I am an embarrassment. And you're here watching it. Okay, anyways, as I was saying before I was rudely interrupted. Brianna's called the PEDS office twice over the last 2 days to discuss his appointment. She was told the first time that they have a court order stating she isn't allowed to access his information, and the second time that John filled out paperwork stating that the court order, there was a court order in this effect. Thus, they won't give her any information except that John has completed forms. What order did John lodge with or claim to exist exist to W's PEDS office? No such order has ever existed. So getting this feedback from the PEDS office is concerning. It's especially concerning that it's now January 8th, months after John was admonished in court for not allowing Bree to attend a recent PEDS visit. Yet the PEDS office is still being told by your client that Bree isn't allowed access to any of his information. As to John's filing on this case, 5/3/24, DVRO denied. 5/31/24, ex parte RFO denied. Thank you. Hey, Angel. Thank you, love. 10/31/24, first order RE legal custody is made in this case, and it's stipulated order for joint legal custody. 15/25, ex parte RFO denied. Only order made is for Bree's visit to occur in California. 3/24/25, ex parte RFO temp order as to sole physical custody only made to John, and for Brianna's visits to be professionally supervised. John's, and it lists all the names. 3/27/25, DVRO number 2, all denied again except for orders not to abuse. W never protected party, no change in custody. 5/2/25, hearing. John was admonished at this hearing for not allowing Bree to be present. What just happened? Present at W's recent PED appointment, and ordered that she was allowed to participate in these appointments. 8/27/25, DVRO. This is the first date on which John was awarded sole legal custody. So if we find out John told the PEDS office prior to this date that he had sole legal, Brianna wasn't allowed access to W's record, Brianna wasn't allowed to be at the appointment, etc., this is going to be problematic. Did she even ever try to get the information prior to then? However, number 5, the section of the court would like to fill out if Brianna had no access to W's records, is entirely blank, meaning none of those orders were made. While John has the temporary ability to make unilateral decisions as to W's health, safety, and welfare, he has never had the right, nor has there ever been an order that Brianna has no access to W's medical records. Please confirm that John will call the PEDS office immediately to remove whatever restrictions he has placed on. Medical concerns, I'm not going to read any of this. I'm sure there's stuff that I can flip over, but to me, his medical concerns is none of our business, so I'm going to skip past that. Okay, now, let's go up to... Okay, so here's Taylor's response to that. Hi, Lindsay. This is the first I'm hearing of any issue about with W. Your client appears to be fabricating new issues now that court denied her request to rebuke Family Code 3044 presumption or allow her partner to be around W, and her extensive violations to the existing orders have come to light. Let's read that again. Hi, Lindsay. This is the first I'm hearing of any issues with W. Your client appears to be fabricating new issues now that the court denied her request to rebuke the Family Code 3044 presumptions or allow her partner to be around W. And her extensive violations of the existing orders have come to light. I love me a spicy Taylor. As I've mentioned to you repetitively, I will not litigate this case through emails. A simple email asking me to reach out to John to try to resolve an issue for your your client claims to be having with communication with her pediatricians would suffice. Again, because look, this is how Lindsay always sends an email. You see what I'm saying? That's ridiculous. That's crazy. No one needs all that. That's why Lindsay's like, all you would have had to do is, and then here's Lindsay's. Short, sweet, to the point. And here we go. This is from the bottom. This is Lindsay's response. It's always long. She says, counsel, referring to a toddler's, okay, her issue. Are you saying it's John's position that the fact that is okay? I just skipped out of everything that they're accusing Baby W of doing. Recall, I brought these issues to your attention because John is seemingly refusing to engage with Brianna about them on OFW. When he does this, I always have to turn to you for help, as my client has no other recourse. Hopefully, someday John will try to co-parent with Brianna better. But for now, this is what he routinely does on OFW. If both you and John are choosing to shut us down entirely on this topic, litigation will be our only choice. But we don't wish to file RFOs that could be avoided through meeting and conferring. You have regularly excused yourself from responding to my emails in substance with that same line, I will not litigate this case through emails. And quite frankly, that's getting old. As lawyers, it is our duty to try to settle as much as we can outside of court, not push litigation. FC 271 echoes the same sentiment. Unlike what John has done since the inception of this case, we don't wish to file RFOs for every dispute. That doesn't make sense for anyone unless John's main motive is the public attention he's getting every time he files a new RFW. Lady, shut it. If you read my email, you'd see we were trying to understand what John told the peds office when both as to the orders of of her issues. She in red underlined. I will ask this again. Please confirm that John will call the peds office today to remove whatever restrictions he has put on W's account that preclude Brianna from obtaining this information and records. Yeah, another one from Lindsay right away. Taylor didn't get a chance to respond. Oh, wait. No, sorry. I apologize. This is to Lindsay from Taylor. Jen, me too. She says, listen, Taylor says this. You are not a medical professional and neither is your client. Spicy Taylor. I love me a Spicy Taylor. Okay? You are not a medical professional. Neither is your client. Okay? Perhaps W just isn't very comfortable around your... Oh, I love her. Hi, Leah. Let me read that again. Perhaps W just isn't very comfortable around your client because she rarely spends time with him. Oh? I am aware that W has had regular medical appointments, and despite your client throwing a fit about being able to attend, including while limited to supervised visits, she has rarely opted to do so. Well, ain't that a bitch? So you're able to go, but you choose not to. But now somebody in October said something in your comments and you've taken it and you became a runner and a track star and you're just running with it. That's crazy. Let me continue because I love a good Taylor email. Your client does not... Thank you, Ladybird. Your client does not have legal custody. My client is not going to schedule unnecessary appointments because your client decides she thinks the child has an issue. Particularly if he does not experience the same issues during his parenting time, your client is not present for my client's custodial time. She has no idea what W's normal behavior is like. Amen. Amen, Taylor. Take her to church, okay? Take her ass to church. Yes, we do love us a Taylor. For you and your client to accuse a not even 2-year-old child of what they're accusing. And says, and I have also seen social media posts reflecting that your client is also saying as much publicly. And is. She sure is. And she says, it's deplorable. And is that as well. Brie absolutely has been on live on TikTok talking about how she thinks this, yada, 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 and why. And I said it way back then, and I'm going to say it again now. You're not around him enough to know to make those decisions. And the fact that you are pushing for your child to go through some type of treatment because some yahoo said in your comment that the child doesn't speak around you because he doesn't know your ass. Anyways, back to Taylor. Your client has the right to attend all medical appointments. She has chosen not to be there. Your client has the right to get information from W's doctors. I have asked my client to work with a pediatrician to figure out what was going on. I understand there have been communications between your client and the doctors previously, so I take issue with your immediate accusation that my client is somehow responsible for any issues your client now claims to be experiencing. I love her. Oh, God. Okay. Now, this is from Lindsay to Taylor at responding. Not even a hello, nothing. I'll ignore your personal attacks on Brianna so we can stay focused on the topic at hand. An adult doesn't have to be a medical professional nor a parent to be concerned that a toddler, whatever. Again, I'm not going to say what they're accusing. For reference, see page 3. Okay, I'm not going to read that either. They are really pushing this diagnosis. That is crazy. Anyways, you'll see that she's just given all the spectrum bullshit. I'm not going to read all that. Sorry. No. We never accused him of being delayed, but we're just saying. My email below said W appears to have... Okay. I'm going to read this part only because it doesn't state specific stuff, and I hope that it's okay. She says, we never accused W of being developmentally delayed. My email below said, W appears to have noticeable developmental issues, mainly due to his complete lack of talking. That's saying that he's developmentally delayed. What are you talking about? That's the same damn thing. Yeah. I'm going to skip over all their whatever. Your vague responses aren't helping us understand what John's position is. Since you said John doesn't experience these same issues during his parenting time, are you saying that W is routinely saying whatever words at home? But he only does this around John and his mom? Can you share any videos of that? That's absolutely normal. That is 100% normal. Parenting class is absolutely needed for her and Lindsay. Yes, kids talk very openly at home where they're comfortable and not around other people. This is absolutely crazy. What a waste of time. My client can't attend W's medical appointments when they're not scheduled during her parenting time. Recall when she said she has to schedule one last year, he refused, which led to the 5-2 order. She can attend them via FaceTime. That's what she just said. And Taylor responds back, refer to my separate email about my position on Family Code 271 issues. John is going to reach out to the pediatrician and resolve the issue. Okay, so that's G. Let's go to Exhibit H. See if we can get through this today. Okay, Exhibit H, more Family Wizard. Okay, on the end of it. Okay, yep. This is from John to Bree. I'm not in agreement with scheduling and evaluation unless and until such an evaluation is recommended by his pediatrician. I'm not willing to discuss this any further. Perfect, sweet, to the point. There's no reason to have it. Brianna says, you're in complete denial. Bree, you really need to stop. You're in complete denial of his delays. You're making this about yours. He's making this about himself. You are making this about yourself. Oh my God, this poor child. You're making this about yourself and your own feelings. Early intervention is very crucial and the best thing for W. You lied on the 18-month paperwork. And how can his pediatrician recommend him for testing? Do you think hold on, Bree. So you're telling me that you think the pediatrician comes in and just reads the thing? Okay, so everything's good. All right, we're out of here. No, they sit there and actually they talk with the child. I know, again, let me remind you, my youngest grandbaby is literally a month and a couple days younger than baby W. They ask my daughter how many words she speaks. What do they say? And the doctor goes right to her and has her point to colors, has her say all the different words. They make her say all the words that my daughter is saying they know. They don't just read a form and be like, all right, cool, check it off and you're out of there. Stop it, Bree. Stop it. Stop it. It's fucking ridiculous. Anyways. You also ran me around in circles for 2 weeks saying you're going to schedule an appointment, and now you're saying you've decided not to and don't feel like talking about it. It should be no issue to take him for a simple evaluation. You go take the evaluation. You go take the evaluation for yourself first, and then come back and let us know if it's simple. You're trying to put your child, who's not even 2 years old yet, you're trying to put your child through more things than what he doesn't need it. You are pushing childhood trauma onto him. For what reason? If the parent who has full physical and legal custody of him is stating that he talks, that he's meeting all of his milestones, you said that you got access, that you were able to go in and look at different stuff. The doctor would have, if the doctor had concerns, the doctor would have said at that point that there was concerns in the delay, whatever the case may be. The doctor's not saying it. You and the one person that commented are the only ones saying it. This is actually disgusting and disturbing and almost borderline medical neglect on your end, Bree, not his. He has taken him to the doctor. He has got the evaluations. They've all come out okay. You are really Angel, are you still in here? Angel's still in here. Dang it, I was hoping Angel's still in here. I wanted to ask her. I wanted to get her thoughts and opinions because, she did CPS investigating in California for 30 years. Oh. All right, I'll reach out to her and see if I can get her. Okay, so that's what she said. He responded back, well, you shouldn't have asked at all. I agree. I already said I wasn't going to discuss it until the pediatrician recommends it. Okay. She responds back, how do you expect me not to ask about the well-being of my own son? I am his mother. I have serious concerns, so I'm going to ask. Accept that. You want to be the parent in charge so bad. He is. It's not like he wants to be so bad. He is. So bad. So be an actual parent who doesn't minimize the other parent's concerns. Oh, see, thank you. Schedule an appointment. I'm not reading that. Like I said before, you keep saying that you want a pediatrician to recommend it. How could they recommend it when you lied on the paperwork? My concern should be enough for you to schedule. No, it's not. How? First of all, how do you even have a concern when you're not around the child at all? You're not around him. 1, 2, the pediatrician sees him, talks to him, communicates with him. The pediatrician said no. Bree, the answer is no. Shit. Annoying. Okay, this is Exhibit I. This is from Bree to 2K. W's pediatrician sent me a letter with some information. It's on his BSW account. There's some information about set an appointment. I'm going to call them tomorrow, unless you want to call. John responds back, I'll call him, have a good day. Okay, here's the number. Let me know what they say. Okay. Exhibit J, more OFW. This is from John to Bree. Tomorrow morning, I'm enrolling W. This is his school schedule. After I enroll him, I will follow up with his pediatrician, go from there. Bree responds back the next day. Are you guys up? How's it going? This is at 6:53 a.m. Are you up? How's it going? He's not in school yet. It's 6:53. Just because you were up all night and you're getting ready to go to sleep now. It's 6:53. John says enrollment at 9 o'clock. A normal time. A normal time. Yeah, actually, yeah, you're right. Yeah, that was... Ooh, OC, thank you, love. Let me get a little massage. I need it. My shoulders is tight. Yeah, that was 4 a.m. her time. Okay, so John says enrollment went good. Bree, did they give you the information for watching the live feed? John says, I think part of it's missing. He started today. I'm not giving anyone access to the link so I can protect his privacy. I will send you pics and updates from his school. She responds, oh, boy, this is really choppy. Bree responds back, the school sends updates every day that your child is there. Are you going to send me updates every day that he's there all day long? Also think it's an app. I don't think it's a direct link that anyone can access. Only a parent can access it to their child. So I wouldn't say that it's just anyone. Also, did you look at the pediatrician appointment? This is from John to her. W10 school, whatever. As stated previously, I will share updates from the school as I receive them. Today I received a photo and shared it with you. I've left a message for the office to call me. She's like, so you're going to send me appointments every day or messages every day? Ding dong. Oh my God. This is email, so it's long. Okay. First email is from Lindsay. Let me take it. Let me take a second. Yeah, I think that's the main issue right there. You hit the nail on the head. She thinks she's in control, and it's really pissing her off. Oh, you guys were 6 daily heartbeats away from 600. But it's pissing her off that she's not in control, and she can't just say, do this, and it be done. Right? She can't do that. She doesn't have full... Thank you guys. Oh my gosh, you guys got there so fast. Thank you so much for the daily heartbeats, you guys. Yeah. Look at you guys. What if she tries to put him on meds if he's not around? Oh, I don't think, well, that would be a whole other issue all at hand. I don't think she would be able to do that. I think, you know, to get to a point of meds, especially that age, you got to go through a lot of stuff. Oh, I agree with you there on John O'Neill Trester. All right. I'll take another drink. Her emails are... Yo, it's going to be a long night. I hope you guys are up for this. If you guys ever want me to get to a point where you want me to stop and finish tomorrow, let me know. I can do that too. But if you guys want me just to keep going, I'll keep going. Okay. Oh, we're on 74 of 93. We're good. We'll push through. Are you guys good to push through? Keep going? Got you. Okay. So this is from Lindsay to Taylor. Hi, Taylor. I want to start out by saying we understand that John has temporary sole legal custody of W right now. We know that this means John can make unilateral decisions of W for now. However, we don't understand is why John seems to believe that this means Brianna isn't to be involved at all in decisions being made for W, such as the recent daycare enrollment that John didn't give Brianna a 24-hour notice about. Sorry, that's going to be a thorn in my side. That one's going to irritate me because, again, you guys know how daycare works. There's usually a big-ass line, and then they call and say, okay, we have an opening. What do you mean? We do love the TikTok shop, Pinky. Thank you guys so much for all the daily heartbeats. You guys are so amazing. He should at least be having conversations with Brianna about decisions he's considering making for W, not doing everything entirely behind her back, then withholding information from her after he tells her. This is basic co-parenting, and John right now is not co-parenting whatsoever. Instead, for lack of a better description, he's conducting himself with places like the pediatrician's office and the daycare facility as if Brianna is deceased. or can't be located and is completely absent parent from W's life, which has never been the case. Well, Lindsay, let me tell you something. You're right, John has full legal sole custody of baby W. And he has that because of your client's actions. If your client didn't do what she has done and continues to do, and that is very apparent by all of this right here, he wouldn't have sole legal custody. Matter of fact, if you rewind back, he's always said he didn't want to have full custody of baby W. He wants baby W's mother in his life. She didn't want to be in his life. Let's rewind back again. They were initially given 50-50 temporary custody. He had 2 weeks, she had 2 weeks. What happened on her 2 weeks? She didn't want him. She gave baby W to John an extra week. That is how the whole thing came about, that he had him for 3 weeks and she had him for 1. Because she only kept him for 1 week. Even before John had custody, the baby was with the nanny or whatever else, or she was completely inebriated and unable to take care of the child on multiple occasions. So no, it's your client. You can't push this stuff off on John when your client's behaviors are the reason that put them in this situation. You can't act a damn fool, neglect the kid, never come around. Just the fact that she says, there's nothing important in Texas for me. What? And then all of a sudden, somebody said something, or she never mentioned anything. Amy! Did you just love bomb me? I like it. Thank you, love. She never said anything about any issues until that one person made a statement, excuse me, in her comments back in October. Anyways, let me finish. You and I both know that no bench officer appreciates a parent trying to cut out the other parent in this way when the other parent is trying to be involved. Bullshit. Brianna was the first one who brought up daycare to John on OFW this summer when things John said in a TikTok live created rumors online that he was enrolling or had enrolled W in daycare. She messaged him on 6/18/25 and asked, and I emailed you as well. And he wrote back a hateful and indirect response. So that was the end of that conversation. So that brings up my point exactly. If in June he was talking about wanting to enroll him in childcare, that means he said, "Thank you, happy Friday." If in June he was wanting to enroll him, but then he had to sit on a waiting list for June, July, August, September, October, November, December, January, 7 months. So now you're telling me, thank you, that he gets the call, okay, we have an opening. Do you want it? If not, I'm going to the next person. He need to say, wait, 24 hours. I need to contact the parent who doesn't have any custody, isn't around, doesn't ever have a say on anything. I need to give her 24-hour notice. And then they're going to be like, well, sorry, sir, we have to give it to the next person in line. No, fuck that. No, that's not how that works. Anyways, on 1/18/26 at 5:39 p.m., John messaged Brianna to say W was Amy. Thank you, love. I think that's such a beautiful gift. Thank you. Oh my gosh, you guys are at 412,000 likes. You guys are the best. Okay, so on 1/18, 5:39 p.m., John messaged Brianna to say W was starting the next day. There was no conversation about daycare enrollment at all in the last 6 months since Brianna first brought it up to John. Can you please help me understand why John failed to give her the courtesy of even a single conversation about the topic? Well, bitch, I just told you. He doesn't need to because I just did it for you. I just told you exactly why. I don't know that that's what happened, but I'm just assuming because I know how daycare works and that's what happened with all my grandkids. Anyways. or why he didn't have the courtesy of giving more than a 16-hour notice. Simply put, this conduct is unacceptable. Again, I just told you why. You have a wait list. You get the call, you take it, or boom, you're out of here, right? Even more concerning is that what John is doing with the daycare facility this week tracks exactly with what he did with the pediatrician's office. We could give him the benefit of the doubt if that happened once, but not twice. But now twice. And on the coattails of the pediatrician's office issue, no less, we now have to assume he is doing this intentionally. As soon as Brianna received notice of W's enrollment, she first asked John to access W's records by the way of the app that the place uses, which also includes a feature where you can see pics and videos of W at school, and John said no. On what basis is he denying my client the right to her son's records? As I said, thank you, love. As I said in our pediatrician's office email thread earlier this month, at no time has there ever been such an order in this place, so it's unclear why John's words indicate he believes otherwise. Brianna's next called the daycare on Monday, and they denied her any information and said they'd have to reach out to the lawyers. To date, my office has received 0 calls or emails from anyone at the facility. Brianna called the daycare again at this time, and this time was told that you told the facility that Brianna isn't allowed to have any information on W. The lady also said that someone told her, not you or John, that Brianna isn't even allowed to be around W. What information and or court docs did you and or John provide to the facility to make them believe any of this is true? Well, how would they know if it wasn't her or John? How would they know any of that? We both know none of this feedback Brianna just received from the facility is true. So I really hope what the lady told Brianna wasn't true, Ari, what you said. If it is true, you had solo conversations with the school. Thank you, Amy. I suggest giving me the professional courtesy of being included next time in a joint email so that there's 0 confusion about who's saying what and when. Please advise immediately as to what you and John told the daycare facility. Taylor responds back. So annoying. Hi, Lindsay. Provide my authority that requires us to provide any of the information you are asking for. Please also provide me authority that requires me to involve you in my communications with potential third-party witnesses. I love Mia Taylor. She's like, you're asking for something you're not entitled to, and I want you to provide me the verification that I need to do so. I'll wait. Brianna complained about W not being socialized or delayed, and movements. I'm obviously paraphrasing and speaking from memory. And in response, John was receptive to the idea of allowing W regular opportunities to engage with other kids and enroll them in preschool. He immediately notified Brianna of the details of the school. I am aware that Brianna has since called and cussed out the school. This jeopardized W's enrollment and highlights the needs for continued safeguards protecting John from Brianna. I see an extension of the DVRO coming up. Let me read that again. I am aware that Brianna has recently called and cussed out the school. This jeopardizes W's enrollment and highlights the need for continued safeguard protecting John from Brianna. There is a restraining order in place. Your client has repeatedly violated existing orders, including since the permanent restraining order was issued. John is going above and beyond to involve her while trying to protect himself from further harassment. She received information and immediately began harassing the school. The live stream feature will not be shared with Brianna. She has a history of doxing hers and John's location, as well as removing W from locations where her visits are to be exercised and concealing W from John, all in violation of court orders, including since the permanent DVRO has been issued. In addition, Brianna having access to the live stream puts the privacy of all of the other children at risk. Absolutely. Absolutely. You guys, I'm not bringing anybody up right now. Nothing nefarious happened with the pediatrician's office. Your client's lack of involvement until this month is the sole reason she was not immediately able to communicate with the doctors. Didn't I say? I told you, remember I said that. I said, listen, you can't just not be there all this time and all of a sudden pop up at 18 months and be like, oh, by the way, I want all this information. No, ma'am. They don't even need a court order. Where have you been? Who are you? Okay, maybe read that again. Nothing nefarious happened with the pediatrician's office. Your client's lack of involvement until this month is the sole reason she was not immediately able to communicate with the doctors. There had never been a need to exercise a release before this month because she had made no effort to communicate with them previously. Winter is developmentally on track. Thank you! And she is still harassing John to demand that he schedule an assessment when no such assessment is recommended by W's pediatrician to date. John will continue following the recommendations of the experts when it comes to exercising his legal custody authority. I love Taylor. Yes, girl. Yes. Absolutely. Let's see what Lindsay had to say about this. Oh, another fucking book. Oh my God. 4 pages. A 4-page response to that. Literally, mic drop, right? There should be nothing left to say. Nope, a 4-page response. Oh my God. I need another cough drop. I'm losing my voice. This is crazy. Lindsay says, hi, Taylor. I don't need authority to support a request for you to extend basic professional courtesy to me. Thank you, love. For the sake of the reputation of all 4 of us with W's new daycare, I'm confused as to why you're not wanting to work together on this. I think an attorney would want to ensure that a facility as important as a child's daycare was given all the correct information in a manner that is transparent to hopefully eliminate he said, she said. But since you're fighting me on this, I'll set up a joint email myself. I just called the facility and obtained an email address to use after verifying with them. They don't even have the DVR on file. Well, what did that just tell you? You ding ding? Lindsay, front and center. You, Bree, scoot off the circle. Bree, scoot over a little bit. Lindsay, you, in the round circle, crisscross applesauce and listen. You just accused John and Taylor of doing something nefarious, something crazy. He didn't even have the DVR on file. Meaning he's not trying to prevent Bree from being there. He's not trying to prevent Bree from contacting the school. The school and the doctor's office don't know who the fuck she is because she has not been around. She has chose to not be a part of her child's life besides her visitation. You said it in your own damn email. You thought that was a big aha moment. Well, the school doesn't even have the DVRO. Because he's clearly not trying to block her from being able to get to see or get the information on her son. Dum-dum. All right, now move over, Bree. Sit back down. Matter of fact, just, Lindsay, stay in there with her. You guys can both sit in the circle. The lady said John just gave her the... Oh, you mother chucker. He went right back to the beginning. Good thing I know what page I'm on. Okay. Oops. Give me 1 second. Okay, here we go. Wait, now how do I get rid of that? Oh, there we go. Okay. Let me make sure I'm on the right one. Hold on. Okay. Oh, I was on such a roll. I don't know why this always does this. iPad always does this. 24-hour notice. Okay, here we go. Hold on. Justin Taylor. This is the one. Okay, here we go. Sorry, guys. I'm back at it. Even my iPad was done. They're like, absolutely not. I'm done with her. Okay, here we go. I just called the facility and obtained an email address to use after verifying with them. They don't even have the DVRO on file. The lady said John just gave them the 1/6/26 order. She said she'd gladly take the DVRO and forward it to her legal team. Also, of important note, either the lady I just spoke to lied to me, or you're being purposely elusive for no reason. As she said, she hasn't spoken to any lawyers yet about W. She said this multiple times. The fact that you're labeling an out-of-state daycare facility as a potential third-party witness when you know you can't haul a Texas resident into our proceedings here is just ridiculous. As you recall, the court interrupted your spiel about the alleged police report that you just received from the San Antonio Police Department. Oh my God, I just swallowed that whole damn cough drop. Sorry, almost choked to death. Oh, my bad. I'm just trying to keep my voice. I have 3 basketball games tomorrow for the Grands, okay? I'm trying to keep my voice. Oh shit, here it comes. Okay. Means I gotta get ready. Okay. As you recall, the court interrupted your spiel about the alleged police report you received from the San Antonio Police Department prior to our hearing, reminding you that she has no power to enforce the PD involvement in our case, and our efforts to do so on your own would likely be fruitful. You don't get to label W's daycare facility as a potential witness. In our case, to not be transparent with your communication with them. This position is absolutely absurd and is setting up both of our clients for trouble. John hadn't been receptive to Brianna's repeated concerns about W. That's bullshit, because she said that she wanted him socializing. He put his ass in daycare. Sorry, didn't mean to say that. He put him in daycare and hopes to help with that. He's listening. And I'm judging. I suggest you review OFW to fill yourself in before blindly speaking to me on this topic based on John's feedback to you. After the 15-month appointment, Brianna asked if W had stuff done. John dismissed her. You previously claimed that Brianna only... anyways, you guys know. Again, for anyone just coming in, I skip over any medical issues, concerns, whatever. I believe that even though it's out here in writing, I believe that they have a right to privacy, and I'm not going to speak upon it, so I apologize. And now that John didn't even tell her about the 18-month appointment, when she found out about it and asked if Winter had a thing done. Again, due to the... Anyways. John was again dismissive. Once she obtained the pediatrician's file after jumping through hoops due to John's misrepresenting to the facility what the orders were, or access to W's records, she reviewed the questionnaire and did a mock version for herself to compare the answers. John answered yes a lot of questions where she would have answered no. For example, he answered no, are a health issue. Anyway, sorry. Again, Brie, you have him 1 week a month sometimes. He has him full time. There's a big difference in comfortability, so I don't think you're in a place to say so. Anyway, let me just read and get through this shit, because this is too much. She has repeatedly tried to ask him about this and to set up a follow-up appointment for W with a pediatrician. Last week, he responded as if he was going to, but just this morning, he has now changed his tune and said he's not going to do this, and he's not willing to talk about the issue any further. Again, and as he should. Let me do a quick poll. It's going to be red yes, blue no is going to be the poll, okay? If you have full custody of your child and your pediatrician tells you everything's fine, but the other parent tells you, oh, I have concerns, are you forcing the child to go get an evaluation? Red yes, blue no. Red yes, blue no. If you would force a child to get an evaluation after the doctor evaluated and said the child's fine. I'm going to keep reading while we're doing that. He's now changed his tune. Respectfully, this is not co-parenting. What Bree's doing is not co-parenting either. This appears to be a need for control or a situation of a parent in denial that a child may need help. Anyways, either way, John doesn't have the ability to stonewall my client like this. The doctor said no, ma'am. The doctor said no. To be clear, as I previously shared with you earlier this month on the same topic, Brianna, 8, 7, 6, 5, 4, 3, 2, 1. So 15 people would still get the evaluation done and 495 people would not get it. 14. One hit the wrong emoji. 496. 497. So several of the people that hit yes hit the wrong button. So close to 500 people said no, I would not. Why would I take my son? Not only would you take him, but now you're also paying for it as well. But more, I know John would pay for it if he felt the child needed it. But why are you going to put your child through such a thing? The pediatrician said he's good. You got a parent that sees him periodically, and when she sees him, she's on live the whole time. Yeah, the stress. Okay, let me get back to reading. Because we still have many orders to go. It's gonna be a late night. Okay. She's just saying that, okay, I'm not gonna read any of that. I'm gonna skip over that whole paragraph. I wasn't part of any calls with Brianna in the facility, and neither was John. So I can't speak to the allegations that she cussed out the facility, and neither can John. Again, the DVRO doesn't prevent my client from being present for W's appointment and having access to his records. The judge was very clear about this when John was admonished last spring after we explained to her that he refused to let Brianna participate in a recent appointment. You were at that hearing. It's truly upsetting that you've labeled talking about this as harassment and apparently convinced your client of the same. We should never be teaching our clients that having basic conversations about our child's well-being, as co-parents should do, is somehow harassment. Please pull the OFW messages that you claim are harassment so we can discuss. I've read all of them, and I truly don't see it that way whatsoever. Well, that's a problem too, Lindsay. That's a whole issue all in itself. But I'm going to let you slide because I want to get through this. Labeling John giving labeling John, giving my client a 16-hour notice that W is starting daycare, having no courtesy to even have a prior conversation about it with Brianna, does not remotely equate to John going above and beyond to involve my client. Lindsay, I'm confused here. What was she going to do? She's in another state. Let's not forget, she has nothing in Texas. If she was in Texas, I could say, okay, I understand, because maybe she'd want to go for his first day. Her ass is in California. She has nothing in Texas, regardless if it was 16 hours, 24 hours, 48 hours, or a fucking week. What was she going to do? He had to accept the appointment then if there was a wait list. I'm only assuming that it's a wait list. I don't know that. I'm assuming, because that's usually how it goes. What was the purpose? What was he going to do? What different outcome was magically going to appear by giving her a few more hours notice? He got 16 hours instead of 24. Whoop-de-fucking-do. Anyways, back to reading. I'll calm down. On what basis, pursuant to the DVRO or any other court orders, are you denying Brianna the right to be on the facility app? I asked about that on my call, and the lady said John has to give her access to the app, not the facility. It appears you're creating orders where no such things exist. Once again, which is infuriating. You know what else would be infuriating, Lindsay? If I had a child in said daycare, and all of a sudden I'm scrolling on the tickety-tockety and I see some Yahoo on live showing her child in daycare and my child sitting right next to him playing with them. And you got a bunch of P3 radios because she's always in her goddamn pink robe because she does mattress actors work. And you got the kids on there. I would be pissed about that. I would not want her having access to a live stream of my children. Abso-fucking-lutely not. No. Absolutely not. Absolutely not. No. No. That's a hell no, fuck no, all the no's. That's a no. Anyways, Lindsay's emails be getting me riled up. Can you guys imagine can you imagine your child's in daycare with them and you're just scrolling, all of a sudden you see your kid on her page? Anyways, Winter's file, when she called because this was the instruction your client gave the facility. You can continue to throw jabs at Brianna all you want to. I will. But the truth is, her lack of access to W's file there was per John's direction. He has full custody. Linz. We scroll up 18 pages to get to look at 4 pages. That was a 4-page email. Look at cute Taylor's response. Boop, short, sweet, to the point. Okay? I love this. I will not be responding to this email. It is clear you are trying to create issues that do not exist. If you want to speak to me, if you want to speak me to me, well, I don't understand. I think she just means if you want to speak to me with a clear request, free of accusations about me and my client, I will be happy to do that, Taylor. And then here we go. I haven't even got to it yet. Look, here's the response. I'm going to start here. All of that from that short, sweet, simple little point. Oh, yeah. It was still going. Shit, I thought it was done. Another 3 pages. I cannot. Okay. It was Taylor. Okay, so this is from Taylor. My bad. This is from Taylor. Wait, so did Lindsay respond? Thank you, Lindsay. Oh, this is, okay. Where is the beginning of her email? Oh, right here. This is confusing. It doesn't start with anything. It just starts. You guys can't see it. Never mind. Okay. The issues outlined in this is from Lindsay. The issues outlined in my last email are certainly serious issues for us. I'm sorry you don't agree. Okay, I'll copy and paste my request from the last email below. Number 1, please pull OFW messages. Define the harassment. On what basis pursuant to the DVRO? Are any other court orders? Are you denying Brianna's request? Summarizing other issues raised in my last email. She just goes through I'm not going to read her bullshit again. Taylor says, hi, Lindsay. I'm not reviewing and pulling OFW. I fucking love her. I'm not reviewing and pulling OFW messages. My client feels harassed by your client's messages. If it rises to the level where I think a DVRO is being violated, I'll pull messages for exhibits and file an appropriate motion. And will. My client has sole legal custody. That means he has sole decision making about medical and educational matters. He is exercising that authority with respect to W's school and medical decisions. He is not required to consult with your client before acting. He has sole legal custody, not tie-breaking authority. Okay, look at Lindsay. Or not Lindsay, Taylor. My client is not required to disclose his conversations with the school, child care providers, and medical staff to you or your client. You are asking for information you have no right to receive. The school has the orders. I trust they know how to interpret and follow them. Amen. Winter will he has a 2-year appointment coming up, and is apparently standard protocol by his pediatrician. My client is not willing to schedule an outside appointment and disagrees with your client's position that one is warranted. Again, he has sole legal custody, and W is also in his physical custody. My client is exercising his authority to this capacity. As mentioned, he does not have to involve Brianna in those decisions. He has sole legal custody. Yes, Taylor, yes. Put it in there each time. Bitch, he has custody. Not you, not Bree, but John. John has sole legal and physical custody. He does not need to ask you or talk to you or your client about shit. He will do what he wants, when he wants, make the decision for his child because he knows what's best for his child, because he is with his child 24/7, not your client. Matter of fact, your client couldn't shit and all of a sudden she can't see the kid for 3 weeks or for 3 months. Okay? Let's talk about that. She wants to be so damn involved with the child all of a sudden about one damn thing, but she can't shit and she can't see the baby for 3 months. She ain't that damn invested or that serious about it. I'm just saying. All right, so this is Exhibit L. More OFW messages. This is from Brianna to John. John, I just spoke to W's pediatrician for the 100th time. Well, then you can't say that you don't have any contact with them because you done spoke to their asses for 100 times. They're about to put a DVRO out on your ass. They're sick of you too. Everyone's sick of you. You're just harassing everybody at this time. Shit. They're going to give you a call. Ooh. And give you a recommendation to take him in. Clearly not. Once they call you, and they're going to call me and confirm so that you cannot lie and say they did not call you, expect the call. After that, let me know when you have set up the appointment, okay? Fucking John, man. Gotta love the kid. You need to stop calling places being ghetto. The way you acted towards W school is inappropriate. Have a good day. Okay? Tell her, John. Exhibit N. M. M is in mom. Something Bree is not active on. Mom. Something I am all of the time, right? I know it's thinking. Okay, this is, what is this here? Respondent Supplemental Declaration, RE Status Conference Hearing. Okay, so we haven't read this yet. 1/6, this is the January 6th, hearing date thingy-majiggy. Okay, the first one I never read. It just says who she is and whatever. Number 2. The purpose of this supplemental declaration is to lodge evidence that proves John committed serious perjury as to one of the main claims of DV at the recent DVRO trial. This is not being shared. This is not being shared to retaliate relitigate the DVRO, but to shine light on John's complete disregard for his credibility with this court. Oh, you're walking a fine line, love bug. John's testimony, given under penalty and perjury, should be highly scrutinized. Bree, are you sure you want to go there? Listen, I know you don't like me. I mean, technically you love me because you're always here. You never miss it. You never miss shit. You're always over here, and you always ask me to read this stuff to help you out. So I feel like these are one of those moments where you really need my help and advice. So listen, back in this circle, sit down, listening ears, crisscross applesauce. Sometimes, Bree, even though you may, let's just say you have something in your back pocket on John. We're just going to pretend. We know you don't, but we're going to pretend. Again, first class seat to Delulu land. We're there with you. You hear me? Now listen. Sometimes you kind of have to eat some stuff, because are you sure you want to go there on penalty and perjury of all the stuff that you put in? I've clocked, I think on the last one, about 10 different lies that I personally can verify that you lied under penalty and perjury of law. So you may want to really be cautious on what you bring up, because if you bring it up, trust me when I tell you, they're going to bring, louder, thank you, love, they're going to bring that shit up too. You have lied so many times, whether it's in a form that you've signed under penalty and perjury of law, or on the stands, and we've been able to verify it. So you may want to be very cautious while asking John the same thing. I'm just saying, I mean, do you, boo? You're the smartest one in the whole world, according to you. You know, so I'm sure you don't need to take my advice. I've only been doing it for 30 years. Not a big deal. Think wisely. Okay, back to reading. John's testimony given under penalty and perjury should be highly scrutinized. And what I am about to detail illustrates the mockery John made of our DVRO trial. In short, John testified that he was at a hotel in Anaheim on 6/20/25, threatened and afraid, because he claimed Santos showed up outside. The truth is, John was at the airport live streaming with one of his friends, while another friend was trying to lure Santos to the airport, or to the hotel, to fight him. John was laughing about the whole thing on the live stream, even warning the friend at the hotel to be careful about what he was saying, because he was live streaming from the airport. Thank you, love. Number 3, John and I have admitted throughout these proceedings that we rage bait online, making up stories to drive engagement on social media platforms to make more money is one thing, but knowingly lying under penalty and perjury to the court is a completely different thing. It sure shit is, Bree. It sure shit is, Bree. And I know that you didn't write this. I know that your lawyer did. But you have lied so many times. You may want to tell your lawyer, hey, we may want to let this one slide. But go ahead, do you, boo. Content intended to be rage bait is content designed... Oh, I just read that. For example, the weekend before our Monday, 4/21/25 court hearing, John posted numerous times on his Snapchat story, faking that he was flying to the Bahamas without W when he was really in flight to California for court. Oh no, not that. It was Easter weekend, and John had refused my request to extend my time in Texas for W's birthday trip, so I could see W over the holiday weekend, just to turn around and leave W behind in Texas to post this publicity stunt. People online were outraged. Stop it. People online were outraged by this content for various reasons, and John's Snapchat Snapchat stories got reposted all over social media for days following this original post. This in turn drove up the views and clicks to John's TikTok and Snapchat's account, and he made a lot of money based on this increased engagement. Posting rage bait content is to be expected of people like us whom stream online for a living, but lying under penalty and perjury is something more serious. Well, you know what's crazy, Brie? I can actually give you an example of something very similar, actually almost, well, to be honest, it's actually way worse. Let's go back to March of 2025. You were supposed to see baby W in Texas, but instead, and you, even though I get it, you weren't served properly. Clerical error, right? Got it. You brought baby W to California, and you did it so sneakily, and you were telling everybody to keep it quiet at the MILF house when you popped up with baby W at the MILF house. But see, Stella can't stay offline, so Stella was online so people could hear you back there. That's how we knew that you were back in California, right? And then remember how you lied under penalty and perjury of law because you did that whole rage bait that you were there, and then you kept the baby on the bed and you had all the lights, and when they turned the camera on, you saw all the lights and the cameras around that small baby. He was 1 year old then, right? And you had all of those people, all those adults around. There's like 20 adults around him, and other people just yelling the stupid TTS bullshit at him. Kind of like that. That's bad. That's bad for the baby. Number 4, most Jones' testimony was given on 8/25/25 as to specific instance of alleged DV that he showed video clips about. One of the videos shown was an incident he claimed occurred on 6/20/25 at the Sheraton Hotel in Anaheim. Exhibit 74 from the exhibit list, TikTok of respondent's boyfriend showing up to petitioner's hotel threatening to fight him June 2025. Was played for the court. Initially, during his testimony on 8/25/25, John was unable to recall specific dates for most of the alleged incidents of DV, including this one. Thus, when he took the stand again on 8/26/25, Ms. Budnick essentially had him re-testify to all of the same allegations, but had him attach concrete dates to them. It was clear they had sat down together after they left court on 8/25/25 to sort out and rehearse all of the dates for John. For John to what's it say? Regurgitate them the next day. Or could it be because there's so much shit going on, just like in every single trial, you have the option to look at the file to click your memory. All the shit that he's gone through because of you and all of this stuff, it's every single day, Bree. His 2K's name is in Bree's mouth and Sandra's mouth every day. Not a day goes by if you watch them that you don't hear them talk about. So yeah, maybe, I don't know, but maybe he did miss a date. And he had to refresh his memory, right? That's what they call it in the legal world. Refresh your memory. Look at the form and refresh your memory. Anyways, I'll continue. We paid for the 8/25/25 transcript and the 9/5/25 transcript and still do not have it. Well, whose fucking fault is that? It's not John's. We followed up with the court reporter numerous times via email and the phone about the missing transcript. We just recently heard back from her, and she advised she took time off for the last 2 weeks of December and that this transcript have fallen through the cracks. She promised to get it to us ASAP, and we will file and lodge it as soon as she does. Great, that means I'll have another one to read. In that transcript, the court will see John testified extensively about this incident, claiming he was at the hotel when Santos was allegedly outside, and that he was threatened and felt anxious and scared. The truth is, John was at the airport with his friend Chris, where the two were streaming, but he lied to the court on the stand at trial by saying he was at the hotel. Chris is known as Chris Different online and was in attendance at our DVR trial. Number 6, Chris O and John were live on TikTok when on TikTok. On TikTok, when Chris O took a FaceTime call from Chris Thomas, a friend of both men who attended our DVR trial. Chris T is calling Chris O to brag he just summoned Santos to the hotel to fight. Chris T says if they're out front, Santos is getting stomped. Chris O laughed and says John will not be there, panning the camera to John sitting next to him at the airport, both laughing. John takes the phone and warns Chris T that he is on live, so to be careful, presumably about what is being said. Chris O responds, take the mother for everything he got, take his teeth with you, because I would have done the same shit, as he and John continued laughing on feed. John was clearly not at the hotel on 6/20/25 with Chris T, but was at the airport with Chris O laughing about the whole thing, unbothered and unafraid. The transcript of this clip of the live stream is attached as Exhibit A. Number 7, text messages between Chris T and Santos stating at 10:51 p.m. on 6/20/25, Chris T inviting Santos to his location. Come here, tough guy. Then him sending Santos a picture of the hotel sign out front and sharing the location with Santos. Chris T said, it's hard to read. Then at 11 p.m., you're going to have my location for the rest of the night. Prove me you really on that if... Wait, what? Hold on. Prove to me you really on that if you on live. Talking crazy the way you are. 3 laughing face emojis. You know what I do. The conversation ends with 0 acknowledgement of the men seeing one another because they never did. And Christy saying, go get your kid back go get your kid back, both of y'all. Then he can prioritize this. This is hard to read because it's like missing parts of the letters for some reason. These 2 men are some of John's best friends accordingly to all 3 of them. Chris O is the person John used to live with in Florida, and the 2 are currently doing home renovation works together. There is chatter online that Chris O is currently living with John and W in John's new rental home. These are the type of people that John calls friends, does business with, and allows around our son. Well, he sounds great. Let's talk about the people you are around, that you have friendship. Perfect. Listen, wasn't the Rubes just on the phone just the other day, or on FaceTime, or whatever, what is this called? On live the other day, at 4 o'clock in the morning, trying to fight with Jordan? That's who you're going to have the child around, right? So it's, shut up. Shut it. Okay. Number 8. I keep thinking we're almost done. We still have 11 pages on this one. We probably will have to finish some tomorrow. Let me see. Okay. When re-testifying to the same incident on 8/26/25, John testified that Santos and I showed up to John's hotel and threatened him while John was at the hotel. He said he knew we were outside of his hotel because we were making videos outside of the hotel. The court pointed out that she did not see me in the video clip Miss Budnick played. John claimed that a later live stream from me talking about the drama confirmed I was directly involved. The 8/26/25 transcript is being lodged concurrently with this pleading and the testimony I am referring to on page 12 through 17, starting with line 13 on page 12 and ending with line 16 on page 17. I have a question. We're going to pretend this is all true. Okay, remember, first class trip to Delulu land. Let's pretend this is all true. Why are you just now bringing it up? Why would you just now be bringing this up? August, September, October, November, December, January, February. We're 6 months in. Why are you just now bringing it up? Doesn't that seem weird to you? Anyways, John knew he was live streaming from the airport due to the FaceTime call with Chris T. because he told the latter to be careful. He excuse me, he engaged with Chris O on the live stream too, and was smiling and laughing on and off the whole time. We streamers know that any piece of any live stream we ever participate in can be flipped and regurgitated online. Despite knowing there were clips of his live stream all over the internet showing John at the airport during the alleged incident of DV questions, he still took the stand and lied about it across 2 different days of trial. Number 10. There is an app creators use called Rewatch, which allows a user to rewatch any live stream from any creator. The Rewatch platform captures and preserves the date and timestamp of the original live streams, then organizes the content by creator. As seen in Exhibit B, a screenshot from this app, Chris O's live stream from the airport and John started at 10:54 p.m. on 6/20. Again, Chris T started texting Santos that night at 10:51 p.m., telling Santos to come to the hotel. He then immediately called Chris O, who was with John at the airport, something to make fun of the whole situation. I declare independent from perjury law, all of it is true, and da-da-da-da-da. Hold on. Okay. Are you guys hanging in there? Are we good? Why does this not let me scroll up? Okay. This doesn't let me move. Okay, I have to run and use the bathroom. Just give me 1 minute. Let me go use the bathroom really fast. And then we'll be good. Okay? This motherfucker. Thank God I knew where it was. Okay, give me 1 moment. Thank you for reminding me I was muted. Thank you so much, love. Hold on, I gotta put my lotion on. Thank you, thank you, thank you. You guys are so good to me. You guys spoil me. No! Hi, love. All right. Oh. Hi, cowboy. I gotta find out what time I gotta leave for the morning. Okay. This kicked me back out. I told you my iPad is like, I'm done about hearing about this shit. But that's okay, because I know what page we're on. You go to Exhibit A. Oops, hold on. Boom! Delightful! Thank you, love. Okay. All right, we're going to get through. There's only 10 pages left, and a lot of them are blank pages because it's, what's it called? What is this? Oh, shit. How'd that happen? Okay, here we go. Respondents Exhibit A, transcription. Oh, I don't know. Do we want to do this? Do you guys want to read the transcripts? It's like from the live stream. So it's at 005 Wait, where does it say 46C? Chris O, but he's not going to be he, and then it says Chris T. Just called his house out on live. John laughing. Chris T. Do you guys want me to read all that? Yeah, this is pages of just nonsense. Okay, and then this is Exhibit B, where it shows Chris different. What does that say? Oh, get out of here. You guys, stop. My ring light, or my light covers, you guys at 600,000 likes. You guys. Okay, yeah, I think the rest of it I can just kind of skip through to his response, right? Okay, here we go. Respondents request for production of documents set 1. Okay, I gotta do this one first. To petitioner John Giese and his attorney, demand is hereby made, blah, 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 blah. Petitioner John Giese shall serve a written response. I love this. No, they didn't want to provide none of the shit they requested. Don't provide that. But oh, now we're going to request stuff and you better provide it. I love that new gift. That is so cute. The little stock gang gift. Anyway, sorry. Petitioner John Giese shall serve a written response subscribed by him under oath, written 30 days after service on this demand, and shall provide herein, blah, blah, blah. A personal appearance by petitioner or his counsel is not required if petitioner John Giese submits copies and whatever. Okay. Exhibit A, definitions. Oh, well, I'm not going to go through this either. This is just definitions of what documents, persons, blah, 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 blah means. Okay, so that is the end of that. What the hell happened to my light? Okay, now, let's go back here. And we'll do the rest. Go. Wake up. Thank you guys. Listen, 1.5 is still hanging in. We've been on for hours, y'all. I still appreciate you guys for hanging in here with me all this time. And huge shout out to Sammy. Is Sammy still in here? Listen, Sammy always be getting me the court docs so we're able to do this. Stop it. Don't make me cry. I adore you guys so much. Okay, so here is John's response. The first one, oh, let me turn it this way. You guys taught me that too, to go sideways so I can see it. Electronically filed. Responsive declaration for request of order. Okay, restraining orders. I agree that one or more domestic violence restraining order protections orders are now in effect between the parties. Oh, sorry, hold on. Let me respond to this email or this text message real fast. Okay, apologize. Let me go back. Okay. There we go. Okay. Number 2, child custody. I do not consent to the order requested. Okay. Deny respondent's ex parte request in the entirety for lack of showing of immediate danger or irreparable harm to the minor child as required by Code of Civil blah 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 blah. What is the next one? Other. This is I do not consent. Okay, other. Deny respondent's ex parte request in its entirety for lack of showing of imminent danger or irreparable harm to the minor child. Facts to support. See attached declaration of petitioner and petitioner's memorandum point field. Okay. Okay. Here's the response from John. Number 1, I, John Giese, am the petitioner in the above. Thank you, love. In the above reference action. The facts stated herein are my personal knowledge, and if called as a witness, I could and I would be competent to testify under oath the facts set forth within. As the facts herein stated on information and believe, and I believe them to be true. This declaration is in lieu of my personal testimony, blah, blah, blah. Number 1, my understanding is that respondent Brianna Lynn Olson exparte request for order should be denied because there is no immediate danger or irreparable harm to respondent of our son, W. W is happy, healthy, and thriving, almost 2-year-old. Number 2, I am submitting this declaration even though it may be redundant for the purpose of addressing certain accusations that respondent appears to be making about me and W based on the review of various orders. Number 3, particularly since our January 6th hearing, at which the court denied respondent's motion for joint legal custody upon finding that she failed to rebuke the Family Code 3044 presumptions at this time. Respondent has started trying to create issues with W's medical care and education. A, respondent's lack of recent contact with W and my observation of W during contact with respondent. Oh, shit. It's about to go down. Number 4. It should be noted that respondent has not seen W in person since December 28, 2025 at 10 a.m. when her December visitation week concluded. This was the last time she physically had W in her care. Number 5, despite traveling to Paris, France, as well as Dallas and San Antonio, Texas in December of 2025, respondent is now claiming she cannot travel. Respondent chose not to see W in person in January, and I understand she has no further plans to come to Texas to see our child. I understand this because respondent has repeatedly stated she is not coming to Texas again for visits and has made no plans with me to exercise them. Well, number 6. Other than last seeing W in person on December 28, 2025, respondent has only opted to see him virtually 3 times in the past month and a half. Bree, listen, front and center. I'm sorry, I'll get back to that. I apologize. I know you guys are like, bitch, just read the documents and shut up. Bree, front and center. Do you want to know why you don't hear baby W talk? Because you don't see him. You don't call him. That's why. How are you going to have a conversation with him? How are you going to talk to him if you're not ready? You guys are killing me with that. Oh my God, I love you guys. Oh my gosh. That's why you don't know if he can talk or not talk, bitch, because you don't call him. You don't exercise your rights to him. He is too good for you. He deserves so much better than you. I rooted for you, and I wanted you to be the mother that he deserves, but you don't want to be. And that is the issue right there. You are now coming up with every single stupid excuse, and you're going to try to force that baby into shit that he doesn't even need. You have no clue what he can or cannot do because you are not around. That baby's not going to talk to you. He don't know you. My mom always told me, don't talk to strangers. You're a stranger. Stranger danger. Thank you, Melissa. Oh, that irritated me. I'm sorry. I didn't mean to go up. Listen, I'm sorry. But damn it, you don't have 10 minutes a week for him? 10 minutes a week is way too much for you. Oh, the inconvenience. Shit. Oh, shit, not buckle up. Oh, God. Here I go. My blood pressure going to be up. Okay, let me focus. Sorry, that pissed me off. Poor baby W. Okay. Respondent had a 15-minute FaceTime call with W. Oh, wait, hold on. Let me just reread that one again. Other than last seeing W in person on December 28, 2025, respondent has only opted to see W virtually 3 times in the past month and a half. Respondent had a 15-minute FaceTime call with W on January 8, 2026. She did not see or speak to him again until January 23rd, 2026, when I FaceTimed respondent during W's doctor's appointment. So you didn't even reach out. You wouldn't even reach out to see him. John called you from the doctor's appointment. After January 23rd, 2026, respondent had no contact with W again until February 4th when she exercised another 15 minutes. Well, whoop-de-fucking-do. Don't outdo yourself, Bree. Shit. Sorry. Thank you for that, love. Number 7. The foregoing is the only contact respondent has chosen to have with W. Notwithstanding my ongoing offer to coordinate regular FaceTime calls between W and respondent, I am willing to make W available every day for a call with respondent. But respondent largely chooses not to have any contact with W outside of her physical visits. Number 8. When I have observed W interact with respondent, I have observed that he is not very comfortable around her. Amen. We can all see that. I believe this could be due to the fact that he is still not even 2, and he goes weeks or months without having contact respondent due to respondent's own choice. Number 9. I first brought this concern to the court's attention via the declaration filed in connection with our October 25 ex parte request for order. During respondent's visit, I have observed W with respondents in respondent's live streams, and W appears withdrawn and distressed. Amen. We talk about that every time, you guys, don't we? We always say that. He looks empty. He is withdrawn. He's stressed. He's scared. He wants his dad and his grandma. When respondents recorded Winters speaking during the live stream, W is heard repeatedly asking for data. Oh my God, my heart. I noted how upsetting it was for me to see our child in distress and looking for me, particularly as he is still too young to fully understand why every 3 weeks or so I leave him with respondent, who again, he does not even have hardly any connection or any contact between visits. Oh, this is a hard read. Number 10. I've been offering respondent FaceTime calls with W ever since W became residing in my primary custody in Texas since November of 2024, and respondent began exercising 1 week per month with W. As mentioned, she largely does not make an effort to have any contact with W outside of her actual visits. Number 11, notwithstanding that maintaining FaceTime contact with W is between visits does not appear to have been a priority for respondent. W does know how to say mama, and I have done my best to ensure he remembers who she is, both because it's important for him to maintain a positive relationship with his mom, and also to try to minimize W's obvious apprehensions when he sees her at the next visit. You don't deserve this, child, Bree. The best thing you should do is walk away. If you would truly love your son, walk away. I have said, you guys, from the beginning, the worst type of parent is a popcorn parent, and that's exactly what Bree is. W is her only tie left to John. This is heart-wrenching to read. Number 12. I am not present. I'm not present during respondents' visits, but it would not surprise me if she spends more time streaming, she does, or on social media than making an effort to fully engage with W. Moreover, based on the welfare check conducted by law enforcement in San Antonio in December 2025, Winter was found at a family home of respondent's boyfriend, Santos, and respondent was not present when the officers arrived. This leads me to also speculate that respondent may be leaving W in the care of third parties to spend time with her boyfriend and friends during her visitation week. Number 13, a lack of attention to W may explain why respondent does not find him to be appropriately engaging during her visits. I do not experience the same concern at my home. Number 14, to the extent W is not speaking or otherwise engaging with respondent during her visits, as she claims, I do not believe is because W has anything wrong with him. I observe W's normal personality every day, and I do not observe any cause for concerns when he is with me. Respondent has not physically been around W since December 20th of 2025 and has only interacted with him via FaceTime for a total of 30 minutes, plus a doctor's appointment since December 29th, 2025. I'm saving it up for the end. B, respondent's belief that W requires an evaluation. Respondent has recently become publicly discussing on her social media her speculations of W. Although I have attempted to address through counsel the impropriety of respondent's public disclosure about our son's developments, I understand we were met only with argument defending respondent's behavior. Respondent apparently does not see anything problematic with discussing her beliefs about W's need for medical diagnosis for his development on a public platform. He chooses to keep him quiet. Again, I'm not going over anything medical-wise. Number 16, none of what respondent is saying publicly about W is true. Number 17, respondent recently accused me of lying to W's pediatrician about my response on an assessment completed in connection with his routine checkup. I have always accurately reported my observation about W and his development, we'll just say. Number 18, respondent shared with me via OFW that she proceeded to call W's pediatrician repeatedly, admitting that she called for the 100th time. I understood the reference to 100 calls to be hyperbole, but I presume respondent called the pediatrician repetitively within a short time frame, or she wouldn't have made the statement. 19. The basis for respondent's call, from my understanding, is she has been demanding that she be provided with a referral for an assessment. That's what I'm going to say about that. Okay, number 20. I have no reason to lie about W. I've been proactive when it comes to him, and I'll continue to operate that way for the rest of W's life. As I mentioned above, I assume respondent is just trying to find something to justify W's behavior during her visits. Now that makes sense. Absolutely. Yeah, he acts that way with you because he doesn't know you. Other than the request for Winter to get an assessment, and for me to require to confer with respondent in advance of making legal custody decisions, all of the remaining orders that respondent is seeking reflect requests for relief that she already has. C. Request for access and information related to W's medical care. Number 22, respondent already has access to all of W's medical records. Respondent already has access to all the information in his medical care. Respondent is already authorized to communicate with all of W's medical providers and already allowed to attend medical appointments. She just doesn't attend. 23. In fact, respondent attempted to call the pediatrician's office for the first time. Let me read that again. In fact, respondent attempted to call the pediatrician's office for the first time in W's life just a few weeks ago. And apparently the office the office policy required that I execute a release authorizing them to speak with her. Duh! The strange woman anyone can call in and say, "Hey, I'm baby W's mom. Here's his birthday. Can I get his information?" What? No. Neither respondent or I were previously aware. Oh, wait, hold on. Did I miss a policy? Okay. A few weeks ago, and apparently the office policy requires that I execute a release authorizing them to speak with her. Neither respondent or I were previously aware of this policy, and because this was the first time in nearly a year and a half of W having this pediatrician that respondent had ever attempted to initiate contact with them, no release had been executed previously. I immediately executed the release, and I understand respondent proceeded to make many calls to his pediatrician and is now able to converse with the pediatrician's office without issue. Number 24, although respondent is allowed to attend all appointments in person for W, she has mostly failed to participate at all, whether in person or virtually. Despite being aware of all details necessary to attend, I will describe the dates of the appointments since respondent requested an explicit order allowing her to attend appointments and respondent's attendance, or lack thereof, below. A. W had an appointment on May 6, 2025. Respondent chose not to attend in person, but I did FaceTime respondent after the appointment so W could see her. The call lasted 38 seconds. 38 seconds, Bree? Your child had a doctor's appointment and 38 seconds. That's all you had to spare him? B. Winter had another appointment on June 4th. Respondent attended via FaceTime. We both talked to the nurse practitioner. Respondent was reminded during this appointment of respondent's follow-up appointment occurring on the 6th. I attended W's appointment on the 6th. Respondent did not attend in person, nor did she call to FaceTime. She never even asked about the appointment afterwards. You didn't have 38 seconds that day, Bree? I know it's a lot of time. D. Winter had another medical appointment in July. I even reminded respondent we were at W's 15-month checkup. She did not call me or FaceTime me for that appointment and never asked about it afterwards. On September 8th, I messaged respondent on OFW letting her know I had scheduled an appointment for the next day on the 9th. He was not feeling well. Respondent did not call to FaceTime during the appointment and never asked about it afterwards. On September 18th, let me see. He's had an appointment. He wasn't feeling good. I messaged respondent, let her know that I was at the pediatrician's office so she could call me. Respondent did FaceTime me, and she attended the appointment with me via FaceTime. Respondent never checked up on him after that. Mind you, that appointment was because he was actually sick. He went in because he was sick. Never checked up on him after that. I mean, would we expect such a thing when she had him in her care and he was sick? Baby W was running around in a diaper and she was snuggled up with his Winnie the Pooh blanket wrapped around her, so she was comfortable, but nonetheless. On October 28th, I took W for his 18-month checkup. Respondent did not attend this appointment and did not FaceTime me about it. She never asked me about it afterwards. So, Brie, you knew when the appointment was. You had access to go. You had a way to contact to be there virtually, and you still chose not to show up. And then you chose to put in a 93... You're killing me. A 93-page document to blast him about why something that you want done was not done at his 18-month appointment. Well, shit, get off your fucking ass, and if you would have been there, you could have asked about it then. It's not done because he doesn't need it. You don't know him. That's why he don't talk around you. You didn't even have 38 seconds that day. Shit, I guess we should have been happy the first appointment. You gave him 38 seconds of your precious time. You are as sorry. Let me finish. Thank you, love. Trying to get through. On December 10th, W had his first dentist appointment. Respondent did not attend, did not FaceTime, never asked about it. January 23rd, W had runny nose, cough. He just started school, didn't attend, didn't call for FaceTime, no ask. Number 25, I have never kept any information from respondent, and respondent has always been made aware of W's doctor's appointment that she can attend. Number 26, if it is a preschool future appointment, the next appointment date is always located on the summary visitation report. I have always sent respondent every summary visitation report. Whenever there have been last minute appointments, which have occurred a few times because W gets sick, I scheduled the appointment on the same day or a next day appointment and made respondent aware so she can attend. Number 27, any accusation that I am not already involving respondent in W's medical care is completely false. 28, any accusation that I am not adequately addressing W's mental, emotional, or behavioral needs is completely false. D, request for access for information related to the daycare. Number 29, W does not attend daycare or childcare. W was has just started attending school. Number 30, respondent is already identified as his mother on all background and enrollment forms. 31, respondent is already allowed to communicate with the school. I am told that respondent has made repeated phone calls to W's school, including at least one call cursing them out. This type of behavior jeopardizes W's enrollment and relationship with the school staff. 32, respondent's counsel has already sent an email to the school staff on January 22nd, 2026, on which my attorney was copied and to which respondent counsel attached a copy of the DVRO issued against respondent. My understanding is that the school has not requested any follow-up communication with our attorneys. 33, contrary to what respondent would have everyone believe about me, I do consider her input. I consider respondent's concerns about W, I'll just say that, and encourage her to, how do I say this? So basically, he takes into consideration he's put him into school in hopes to help, basically, without me reading the words. Winter would benefit developmentally from starting school, where he would have daily interactions with other kids and teachers. I believe this will help him become more comfortable engaging with people outside of his regular community and familiar circle. I've already seen W's confidence grow and has only just started going to school. I'm excited to see how this continues. Bree, do you know how sad that is? Let's talk about that. I know I was going to finish, but I can't. Bree, back in the circle. Do you know how sad that is? This man wants you to, wants his son to have his mother so bad, and you're so concerned because he doesn't talk to you, that he put him in school so he gets used to communicating with strangers. So he gets used to communicating with strangers so he's okay talking to his mother. Let that sink in for a second, Bree. Your son doesn't talk to you because he doesn't know you. John doesn't have to put him in school, but he said, you know what? I'm going to. Let me see if this will help. I'm going to put him in school. Of course he's going to benefit, right? I'm going to learn from it, but he's going to get more comfortable talking to strangers. Then he'll feel more comfortable talking to his mother. It could never be me. It could never. It's sad. It's sad. It is beyond sad. John has grown so much. He has matured. He is an amazing young man and father. And even though he doesn't have to, he is listening to her bullshit in the back. That's only just to solidify her. But he has to get as comfortable to talk to strangers so he'll feel comfortable talking to the individual that brought him into this world. Literally, Dee Dee, I can't, thank God for 2K. I can't even fathom or imagine where baby 2K would, or baby W would be without him. She's already saying with this new baby, if there is a new baby, that all she has to do is deliver him, then she's back out to partying and drinking, and Santos has to deal with everything and blah, 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 blah. Baby, I know, I do call him baby 2K. Okay, number 34. I did not keep responding in the dark about the school decision. I started looking into a couple different private schools. He's in a private school at that. He ain't just no raggedy-day, rinky old child care center. He's in a private school. That baby's getting an education. He's getting educated, okay? Yeah, absolutely. W2K in the chat for real, for real. The baby is not even 2, is in a private school getting top tier education. Because his mom don't, never mind. Let me just focus. Okay. I started looking into a couple different private schools for W to help with his social development. I found a school that I felt safe and confident enrolling him in. I let respondent know that I was enrolling W into this academy. I let her know the location and the schedule that I picked for W. Respondent messaged me back through FW and seemed to be excited and even expressed a willingness to help pay supply fees. Well, ain't that fucking sweet? Whoop-de-fucking-do. I let her know that I would send her an update on the school as I got them. 35. W started school, and I sent respondent the picture and update from the school they sent me. Later that evening, I got a call from the school that respondent was wanting access to the app/live stream. The second day W went to school, I received another picture/update, and I sent it to the respondent. That night, I got another call from W's school letting me know respondent had called the school yelling and cussing at them. You ain't in the Hollywood Hill. Well, you ain't either. You in Lancaster. But this baby is in a private school. And you were calling them back to back to back, cursing these folks out. And you wonder why your child doesn't want to talk to you. You are going to be such an... Let me finish. And then I'm about to lay into your ass. Number 36, I have not kept anything from respondent, and I have shared the pictures that the school has sent me with her. Number 37, the above referenced school is what respondent is referring to when she mentions Winter's daycare or child care provider. Number 38, the only aspect of W's school that respondent lacks access to is the app/live stream feed of all of the children. And I wholeheartedly agree. She does not need access to that. The school does not release this information to everyone in order to protect the privacy rights, of all of the children at the school. Can I get an amen? It would interfere with W's ability to remain in this school if respondent were to record the live stream. The school has a policy in place prohibiting it from being recorded and photographed. even for private purposes, or otherwise discuss the school's live stream on her public social media platforms. And don't even think, Bree, about saying, oh, I would never, because you would. Because you would. That's exactly what you do, because you don't care about him or his safety or anybody else's kids. It's all about money for you. That would be great. Clicks and views and blah, blah, blah. And that's what you care about. The rest of us that do, well, I don't know about that. I can only speak for myself. I don't do this for clicks, views, money. I do this to get correct information out. You can't even say that about your own child. It's all about money. You would do it the second you had the opportunity. 39. W is not in a daycare. I am W's full-time parent. When I need childcare because I am working, I rely on my mother or my sister to watch W. I enrolled W in school because I believed it would benefit his social development. Number 40. Prior to starting school in January 26, W also participated in swim school and Kids Strong. Respondent was aware when W started swim school and Kids Strong, and she has never asked about the programs or how W was doing in the classes, or if he was enjoying them, or when he goes, or where it's located. E. Respondent lacks personal knowledge about W's behavior or development outside of her visitation. Number 41. Respondent is not present for my custodial time. Although I offer FaceTime visits between respondent and W, as discussed above, respondent largely chooses not to exercise it. W has resided in my custody for all but the first 2 months of his life. 42. I care so much about spending as much time with our son as possible that I lived in Airbnbs for months so that I could exercise physical custody in Los Angeles prior to obtaining the October 31st, 2024 order allowing W to live with me in Texas. 43. I do my best to ignore respondents' negative comments about me, which include claiming that I am never around W, that my mom is actually raising him, or that I just sit him in front of a TV or iPad all day, because I know that respondents' false critiques of my parenting are fueled solely by the fact that, unlike respondent, I do not share a lot about W on social media. Amen. He sure don't. 44. I do not share anywhere near enough content of W on social media for respondent or anyone else to be able to opine about his regular behavior or developmental progress, or warrant respondent's claim that I lied to W's pediatrician about how W acts in my custody. W's medical development, behavioral, social, and academic needs, and any other need he has as he grows, will always come first to me. Bree, did you hear that? Let me read that one more time for you, because I don't think you understand what that means. W's medical, developmental, behavioral, social, and academic needs, and any other needs he has as he grows, will always come first to him. That will always come first to John, but it comes last to you. Matter of fact, it's not even a thought to you. It's only a thought to you when you're not thoughting around. It's only a thought to you when you think that you're going to be able to one-up somebody. It's only a thought to you when you have court coming up and you're thinking that you're going to be able to do something. Some minion over and you put a little thought in your head, and all of a sudden that became your only thought that you can think of. That's the difference. You think of one thought that somebody put in your head, but 2K, his thoughts all the time are always all of his well-being. Y'all have me fired up. I'm going to have a hard time going to sleep tonight. Okay? I still have to eat dinner. That can come later. Number 45. Respondent inexplicably continues to advance a false narrative that I am the one who is not willing to co-parent and am inattentive to W's needs when I have consistently made an effort to involve her and have been the only consistent parental presence in his life. Did you hear that, Bree? Bree, are you back in your circle? Crisscross applesauce with your listening ears? 2K. I have been the only consistent parental presence in his life. 46. I am eagerly awaiting a hearing on custody where I will finally have the opportunity to show the court all of the information and evidence related to my care and custody of W. I am a present and involved father. W is not being raised by my mom, nor stuck in front of a TV or an iPad all day. I am constantly out doing activities with him. I take care of meals, bath time, morning, and bedtime routines. I truly enjoy helping him learn and grow. We are so close, and I'm excited to finally have the opportunity to show the court my strengths as a parent and how much W is thriving when we return to court in April. I declare under penalty and perjury of law, the state of California, the foregoing is true and correct. Okay, I think there's one more for me to read here. I'm going to wait till the... Thank you, love. I'm going to wait. Okay. So there's a couple more. I'm going to wait till the end to give my thing. Yeah, W2K's in the chat. Show 2K some love, please, because I tell you, yeah, that's why I'm like, I'm going to keep it in. I'm going to keep it in. I do need some chapstick, though, because my lips are dry, my mouth's dry, my throat's dry, I'm dry. I don't think I've ever been more proud of a young man that I don't even know. And shout out Mama 2K, because you raised a king. Pinky! Mama 2K, you raised a king. You raised a man. See, Bree did all that, right? In the back about how, she doesn't want you raising W because the way you raised John, you did a damn good job. You did your thing. Listen, nobody's perfect. Nobody is perfect. But the amount that 2K has grown and matured right before our eyes over the last year and a half has been absolutely astonishing. The way that baby boy looks at him when he gets back to his dad, like, let me just finish through so I can get through. No, I'm crying. Wait, what? Oh, I'm good, Jen. I'm good. I got a diet. As long as I got Diet Coke, my blood pressure will always be fine. Okay? I'm okay, love. All right, let's see what this finishes last one up, though. Petitioner's memorandum of points and authorities in opposition to respondent's ex parte request. Introduction. On February 5th, 2026, Respondents Counsel provided ex parte notice via email seeking the following relief. Go away. Brianna shall have immediate access to all of W's daycare records, the daycare's parent application, and shall be listed in W's paperwork as the mother of W. John's attorney shall participate in three-way email communication with the daycare to confirm that, whatever. John shall be admonished for prohibiting Brianna from accessing these records and the parent application at the daycare, as well as doing the same at W's pediatrician office. I'm skimming through this. Moving forward, moving forward at any new medical / dental, vision, mental health, daycare, school provider W for W, John shall ensure Bree is listed as the mother on his paperwork. So that's all you want, Bree, is just to be listed as the mother. You just want to be on a paperwork that you're the mom. You don't want to be around. Don't want to be around. But you just want to be on the paperwork. Oh, I'm the mom. Nobody cares. John shall not misrepresent the court's orders, blah, 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 blah. John shall attempt to include Brianna in major decisions he makes. Yeah, sure, whatever. John shall call the early intervention nonprofit organization by close of business. Oh, sorry, I didn't mean to read that. My bad. What is this? Argument and legal authority. Respondent's ex parte request must be denied in its entirety because no immediate danger or irreparable harm exists. B. Purpose. The purpose of the request for emergency orders is to address matters that cannot be heard on the court's regular hearing calendar. In this type of proceedings, notice to the other party is shorter than in other proceedings. Notice that the other party can also be waived, etc. Blah, blah, blah. Number 1, make orders to help prevent an immediate danger or irreparable harm. Okay. Here, none of the orders requested by respondent are necessary to prevent an immediate danger or irreparable harm of the minor child or respondent. And as such, the ex parte let me go back up real fast. Okay. Sorry, I'm going to go back to, okay, let me see. So here we go. So number 1, make orders to help prevent, is this where I was? Sorry, I'm getting myself thrown off. I'm so tired. Make orders to help prevent an imminent danger and irreparable harm, blah, blah. Okay. Here, none of the orders requested by the respondent are necessary to prevent an imminent danger or irreparable harm to the minor child. As such, the ex parte request for order must be denied in its entirety. A description and assessment of each order requested to be issued on the ex parte basis by respondent is set forth below. Number 1, access to the minor child's daycare records as listed. We talked about that. Number 2, requiring petitioner's counsel to participate in a 3-way communication with the daycare. We were talking about that. Number 3, the request for petitioner to be admonished for prohibiting Bree from accessing these records and the parent application at the daycare. Number 4, the accusation that petitioner is misrepresenting court orders as to respondent's access to the minor child's records, whatever we know about that. Number 5, the request for the petitioner provide all providers with a copy of the permanent DVRO. 6, respondent's request that John shall attempt to include Brianna in major decisions he makes about whatever. I'm just skimming through this because it's stuff that we've all went over. Respondent's request that John shall call the early... Anyways, we're not talking about that. They gave a date to call, whatever. Respondent's request regarding Family Code 6309 and respondent's ability, that the lack thereof, to profound discovery is certainly not appropriate, blah, blah, blah. Okay, B. Respondent cannot comply with the requisite procedural requirements necessary to allow the court to grant respondent's request ex parte relief, including as to the request for the hearings. And then it gives some laws. Here, not only is the relief requested by respondent not necessarily to prevent any immediate danger or irreparable harm to the minor child, as discussed above and further elaborate upon herein below, but the requested relief is too largely based on speculative accusations related to matters above her knowledge. Okay, and then C, I'm not going over a lot of this stuff. Crucially among, yeah. Okay, so there's that. Now let's read the response of what happened. Okay. Minute order. Electronically filed, blah, 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 blah. Temporary emergency ex parte order for child custody, other... I gotta turn this way. To John Giese. Okay, temporary emergency ex parte order of the child custody in the alternative OST to John Giese. A court hearing will be held at whatever, blah, blah. Okay, let me go down here. Oh my God. Okay, I'm fine. I gotta get to number 2. Things like on a damn delay. Okay. Contrary to habitual residence, United States of America. You ready? Here we go. It's what we've all been waiting for. 3.5 hours. Other resources. Denied, bitch. Denied. Insufficient evidence of immediate harm to the minor child as defined by Family Code Section 3064 or of irreparable harm. Respondent may file an RFO. All that shit. Denied, bitch. You are denied. Okay? Denied. 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 Brie, you're denied. No way. I yell and it goes like that. I didn't know that. I would have been doing this whole time. Oh my God. Now you tell me. Brie, you're denied. Listen, you can't come on here and file frivolous. Listen, your attorney may be and you may have Santos and Ruby in your ear telling you that you can do this and you can file for custody, blah, 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 blah. You can't. You can't. Listen, you actually have to want to be able to do something. And you're already setting it up for this way with this child as well, bitch. I'm going to deliver the baby. Santos' life is over because he's going to have it and I'm going to be out. And if I think for a second that was pretend or play, no, I don't. Because that's exactly what you did with baby W. The sad part about that baby is it has Santos as the other parent. The fact that you want to put baby W through a whole ass assessment for no reason when he just doesn't know you. 38 seconds, Brie. Hold on. I'm going to do this. Your child has a doctor's appointment. You haven't seen your child. You want to know what's going on with your child for the doctor's appointment. And so you have 38 damn seconds. Are you ready? We're going to do 38 seconds. I'm going to be quiet for 38 seconds and just read your messages. And this is going to show us how long Brie had to spare to be able to talk to her child. Ready? And go. 38 seconds. Like, what can you talk about for 38 seconds to find out how the doctor's appointment went? Is he okay? What happened? What did the doctor say? You know, I have some concerns. I was wondering why he doesn't talk to me. What do you mean they said that he doesn't know me? He's doing everything. Well, you must have lied. If everything else is fine, you must have lied. I mean, because he doesn't talk with me. What do you mean? No, it can't be me. It's absolutely not me. It's got to be you. It's got to be him. It's anybody but me. Got to go. That's it. That's the amount of time that she has had contact with baby W in a month. 38 seconds. Thank you. 38 seconds. That's not too long. Baby W is probably like, that was long enough for me. Oh, yeah, it'll be interesting to see what the rebuttal is. You guys, I've said for the longest time, I'm going to say, hey, it's denied. Thank you, guys. I'm going to say, I've said from the longest, wait, piano keys alleges essay, what? Embry, incubator, should never be. I agree. Yeah, I've said for the longest, I truly believe that she is going to push and do whatever she can do. She doesn't want to be a part of the child's life, right? But she doesn't want to be like she walked away, right? Which would make her a good mom. But you're doing all of this for what? You would want your child to go through an assessment? For what? What is it going to prove? What do you do? For what? Why don't you go take an assessment, Bree? I think there's a couple assessments that you need to take. Now, I'm not, but if I was your social worker, I would request for you to get a psychological evaluation as well as a drug and alcohol assessment. I'd for sure do that. And then also have you take an anger management class. That would be the beginning steps of what I would like for you to do. On top of the parenting classes, which, you know, who knows? You said that you guys were going to do parenting classes, but you were going to split it up. No sense giving all, you know, baby W only gets 38 seconds, right? So he only gets like a little bit of time with the parenting class, but you guys are actually going to learn to parent apparently for this baby. Who knows? We'll see what happens. But that just reading all of that, we've been online now for almost 3.5 hours reading this. And none of it made you look good. None of it made you look like a concerned parent. Not one piece of that made you look like you were. Thank you, man. It looks like Diez de Muertes. None of that made you look like a concerned parent at all. And then you want to talk about somebody else lying under oath? Honey. Oh, I'm ready for my Hawaii trip. Let's go. We're going to Hawaii. Ooh, I'm going to do my little, you can't see it, but I'm actually shaking on the bottom. I don't have much to shake down there, but man, that is, you guys, I had something totally different planned for today, but when I got that, yes, I was like, okay, we got to read it. And thank you guys thank you guys so much for understanding and accepting. And oh, this is what I'm gonna look like next week too. Yes, OC. That I would not read all of that, and I was going to skip through. I was not going to read into detail about the bullshit that she put out in regards to her medical stuff. So I thank you guys for understanding and accepting that and knowing that that's right. I don't understand why other people will put it all out. Maybe they don't. Oh. I don't know. I will never ever know. But 2K is a blessing for that baby, and almost 1 million likes. No way. Shut the front door, you guys. Oh my gosh. You guys are the best. Yeah, I'm not heading off just yet. But I so appreciate you guys. Yeah, and we just gotta listen. We just gotta keep supporting. I just don't even know what to say. I got love bombed. I'll respond to that real fast. Okay. Sorry guys, we got 3 basketball games tomorrow. I'm trying to figure it all out. 1 million. Let me see. Yay! All out. 1 million. Let me see. Yay! got one of those before. Thank you. Oh, is Tea Junkie in here? Oh, honey, listen. Oh, Tea Junkie can always come up. She knows that. She got an open invite. I just had people requesting while I was in the midst of reading, and especially people I didn't know that I was going to let up. But Tea Junkie can come up for real, for real. Delightful. Thank you, love. You guys, thank you so much. Okay, perfect. Yay. Yes, W2K. Man, I'm just... There was a few times that I started getting emotional, and I had to back off because I'm trying to stay. Good night. Wait. Is that my... It is my angel. Wait. Before you go, can I ask you a quick question? Shit, what was it, you guys, that I had to ask her? Wait, how do I do that? How do I turn my invites off? What did I do? What was it I had to ask her, though? Oh, I think I know. Angel. Let me figure it out and I'll message you. I want to go back and make sure I get it right. Okay, I don't know how to turn them back on. Let me see. Let me look. Hold on. Let me focus. Okay, let me go to settings. Block. No. Marked accounts. I did have a question for her, but I'll email her. Oh, here we go. Oh, there's leftover lasagna. I don't know. Did you really want to come up, or you were just chesting it? Yeah. Tea Junkie, try now, honey. I can't remember. Yeah, it was something about CPS. But Angel, I'll email you later. I need to go back over and look at it. I forgot. I think so. I think it was something about medical neglect. I just can't remember exactly what it was. Recap. Oh my gosh, El Garcia. That's like 150 pages worth of recap. But I will really fast. That's what I thought, love bug. Okay, Tea Junkie, did you want to come up or no? Were you guys just messing with me that she wanted to come up? Did you get me excited for nothing? Yeah, it will be on YT. Oh, she's like, okay. Oh, those requests are off. Dang. Yeah, I don't know how. I turned them off because people kept requesting me, but I don't know how to do it. I am going to do a recap, though. Hold on. Oh, wait, maybe I can request her. Wait, did she say she wanted to go live with me or no? Are you guys just messing with me? She did? Okay. Who said that recap? Denied. Oh, wait, no, it's not that way. Is it this way? Okay. Oh, I can't. Her requests are off. Yeah, her requests are off. Okay, so a quick recap. Basically, Bree, it's not that she requested custody. She didn't request custody per se, but she was requesting, yeah, recap. Bree ain't shit. Perfect. But she requested, like legal custody. She wanted to be able to have access to all of his medical records, his doctor's appointments, his schooling. She wanted more time. She basically lied about all of this different stuff. 2K came back with a great response on absolutely everything, and it was denied. CPS was notified Santos made a false call. That's illegal. Wait, Santos made a call on who? Yeah, but it will be up. I will have it up on my YT. Oh, on his. Yeah, I was wondering why how was he calling his baby? First of all, that's another lie. They said that they showed up at the BM's house to go try to see the daughter. She lives in Texas. How do they show up in California to Texas? I don't know. Oh, she has it on now. Okay, let me see. No, it's still blinked out. I'm terrible at this. Yeah, when I go, I can invite everybody else, but hers is grayed out. She says my invites are off. I say her invites are off. Let me see. Let me see. Is it this way? Stickers, music, background, dual? What does this mean? Oh, no, I don't want to do that. What the fuck is happening? How'd that go? Go away. Oh, no. What'd I do? Oh, no. Oh, no. Oh, no. Oh, there we are. Oh, my God. Now there's a random dot. Wait, how did I just put that there? Oh, my God. Make that go away. No, how do I get rid of that? Oh, shit. Now it's got a random dot here for no reason. Okay, never mind. Oh, wait. Nope. That's not her. That's somebody else. Oh, wait. I wonder if I can do it. So she's not in here. Because you guys said she's live, right? Hold on. Let me do something. Oh, I forgot about that ding dong. Man, I saw some crazy. We'll talk about that later because I saw some crazy stuff yesterday. Oh, guest settings? Okay, hold on. Oh, go into the guest and then... Oh, there she is. Now I sent it. Not her denying me. Oh, no, she didn't. She declined me. Y'all set me up. Got me excited for nothing. Y'all told me she wanted to go live with me and now she denying me? Oh, no, she didn't. Oh, I'm going to go to bed crying tonight. You know, she's my favorite. Try again. Why? So you guys see me cry again? Oh, now it's back to I can't do it. Her thing is blanked out again. I'm not going to be on for much longer, though, because I still have to eat dinner. It's only 11. Oh, I love me some Angie and Tea Junkie, too. She said try. I'm trying, but it's... Oh, wait, not that one. Yeah, it's grayed out. It's only giving me an option. Let me see. Let me try it this way. Oh, wait. Oh, right here it says it's turned off. Hold on. Settings. Turn that shit back on. Allow... Okay, hold on. Can you see, oh wait, how did you guys requested it? How do I do that? Anyways, so I just turned it on. Maybe now she can do it. Yeah, because now hers, oh, there she is.
She thinks she got it.
Thank you. Hi, love.
No, you're not.
Hey, how are you?
Doing good. You know, just
Yay.
over here reading this nonsense, this bullshit.
I heard people were coming into your lives.
Fuckery.
Yeah.
Huh?
I heard people been coming into your lives.
Oh, you know what? When I'm reading this stuff, I'm not even paying attention. So I'm sure I'll have to go back and look at the comments. I'm sure they were.
Oh, that's interesting. How has
Oh,
the
I'm
week
sure.
been?
Good. Just, chilling. We've
I
had
love
some nice
y'all both
weather.
so much.
Sorry.
We love y'all so much. Thank you. Not you having TTS too.
Yeah, it's easier when I'm playing my game. Have you finished the court docs?
Yeah, we just got done.
What do you think about it?
Am I shocked? No.
Right.
I wish I could be. I think it's absolutely ridiculous for an egg donor to want to put a child through something
It took her
so
3
ridiculous.
hours to read lol.
It did. No, and I won't read any of the medical documentation. I don't read dates. I don't read medical stuff. But for her to want to put that child through that is absolutely crazy when the child just doesn't know her.
Right. He just
And then the fact that 2K even put her in school, he put him in a private school to learn how to engage and communicate with strangers just so he can have a conversation with the birth giver blows my mind. How do you, and that was at her request. How do you accept yourself as as a birth giver when your child has to learn to talk to strangers just to talk to you?
Mm,
You
that's
know?
true.
Crazy.
I feel
Yeah.
like Bree really just needs to get a place in Texas just to be closer because even if she doesn't see him that often, at least the place he's living at, he can associate with his place of living. Because right now what's happening is she barely sees him once a month, yeah. And
Mm-hmm.
then he's at this unknown place every time he's coming. So it's like, girl, who are you and where am I at the same time? Like it's too much for a little kid to go through.
Yeah. I told her that she was in my live one day, and I told her, I said, listen, the absolute best thing that you can do, not that you give a shit, but the best thing that you could do is rent an apartment in Texas. One, it's going to be the same or less than an Airbnb, right?
Mm-hmm.
Rent an apartment. So then he will start to associate every time he goes over, he will associate it with the exact same spot. Also, you don't have to get rid of the shit every time. So he's also going to be able to associate that's my room. Those are my things. I'm supposed to be. And you know what she said? Or I can just rent a storage unit. Then rent a storage unit because that just tells me then you don't want to be there. You don't want to be a part of your child's life.
Right.
If that's your response, is I'll just rent a storage unit.
I mean, she could have stayed for the next 3 months until court, or 2 months, I guess, to court. She could have stayed in Dallas nearby him, even though she. I
Yeah.
mean, there's no difference from what she's doing in LA on the couch compared to what she can
Right.
do in Dallas on the couch too. I mean, she's not doing nothing. You're not doing anything. So why are you missing so much time with your child? Like you're not doing.
She's not even making her 15-minute FaceTime calls. That's the part literally that blew me away. She's only made two 15-minute FaceTime calls and one 38-second phone call.
What are you supposed to get out in 38 seconds? That's what I want to know.
I just played it off. I just because it was after a phone call. I put the timer on for 38 seconds to see what we could get out of it. Nothing.
Just to say she called.
Oh, three. Yeah, three. Sorry, I apologize. 3 FaceTime visits. She gets
one. Of them was from 2K in the appointment, so I'm pretty sure he probably called about that one.
Yep, he called. Yep, that's what he said. Is that he said he called. Listen, I've said from the beginning, she does not want to be there. She does not want to be a part of the child's life. She doesn't want to walk away. She wants it taken away because she feels like then she's the perma victim, right, and she can blame somebody else. No, bitch, it's all you. It is your actions that put you in this situation. Yeah. Baby W deserves so much better than you, and praise God for 2K.
Amen.
I can't even fathom where that baby would be if he didn't step up and be the father that he is.
And they're about to have another one.
That's crazy. And yeah, that one has Santos to lean on. And she's already saying that as soon as she has this baby that Santos is taking care of it. She's like, nope, I need my sleep. I did my part. I have to carry it for the 9 months and then I'm done. I have the baby. No, he's on duty.
I don't know. I don't understand what's their plan? What's the plan here? So they live in the boondocks in the desert. She on the couch with her robe. I know she got that funky robe on still.
She always do. Mm-hmm.
She's on the couch. Okay, she's gonna have the baby. Then what? What's the goal? Like what are y'all doing with y'all lives?
That's my question. Yeah, I don't know. It's to me, it's.
I feel like also if the court gets moved to Dallas, I don't see her pursuing much after that.
Oh no!
Like that would be it. And so
no, I think April will be closed. I think they'll complete the move away order, and then everything will be moved. And I think she'll, and I've said this too from the beginning, she's just going to slowly drift away. I mean, she's already doing it in regards to the FaceTime calls. If you can't even make that, you can't even do your 15-minute FaceTime call.
2K gives her the option.
Yeah.
Every day, all day if she wanted
to. Yep. And what are you doing? It's not like you're working and you're busy and you're doing whatever. You're sitting your ass on the couch.
Doing is making fake accounts, threatening people, thinking shit that's funny on TikTok. Okay, yep. Over here, Santos in my DM talking about something about Fulio. Girl, oh, I'm so scared of you, Santos.
I know.
Like, ooh. Yeah, like that's what you're wasting your time doing when you can be focusing on your son. You worried about TikTok and everybody else that's going on TikTok. How about you FaceTime your son? Call your son. Right. Like do something. And then she
And
claimed that
FaceTime's
her blood pressure was normal for her high risk today. So that's interesting.
well, she came out and said like right after the court thing, because remember when she filed that or the day before court, she put in her request. Her request was visits are gonna be in California. John would fly him there. She would fly him back. Now I don't know why they would do that. You don't return them. John should be the one picking him up for return, but nonetheless. So the day before court, she could fly. She goes to court, finds out no visits in California. She tried to bluff the judge and said, okay, well, I have a high risk pregnancy. The judge said, okay, well, then you can have a FaceTime call once a week. And then right after that, she came out and said, oh, I'm not high risk. I was just constipated. So she was just full of shit. And then she came out now and said, now it's her sciatica. That's not high risk. Is it a pain? Yes. High risk was, for example, when I went into full-blown labor at 24 weeks,
Right.
3 centimeters dilated in the hospital for well over a month, that's high risk. Not being full of shit and your back hurting, bitch. That's life. I'm just like, God damn.
She makes up her own diagnosis in her head. I think that's what it is.
Right.
And
She
also,
does.
no, her fans doesn't help her because her fans be like, "Girl, oh yeah, I had this. I think you had this." And the Brie be like, "Oh yeah, I have that." Like, girl, you
Right.
doctor.
Well, and it's just like this whole thing right now. All this shit that she's requesting, all stems from one comment that happened back in October.
Oh yeah, and during Thanksgiving when somebody mentioned
Yeah.
the autism.
Yeah, it's from that. Ever since then. Oh yeah, it was Thanksgiving. You're right. Ever since then, that's been a thing.
Yeah.
Just literally blows my mind. I don't know.
We're crazy too.
Oh, a mess, an absolute mess. I do hope that I haven't been on because, like I said, I watched the grandbaby and I come on. I do hope that people don't have like all of the information out. Like, I hope they redacted stuff. I don't know. I haven't seen yet, but I hope info is redacted and it's just not all his medical stuff out there.
Right.
Crazy.
Did you report his threat? No, I didn't. I just screenshotted and posted on my story.
Oh, did you get more?
Yeah, I got a message from Santos. It's probably 3. No telling. I feel like Santos don't have access to his own shit. Santos DM'd me yesterday. The other day, remember when he posted what did he post? He posted something on his Snapchat saying thank you. Saying what did he post? It was a picture of Bree. And it was like F around and find out something like that. Like I got people, some type of threats that he think he's scaring people. Yeah. So then he DM'd me and was like, let me go find this man. Why can I not find him? Santos.
Is that what makes him feel big and bad? Is like threatening all of us? Because I have so many threats from him. Like, is that what makes him feel manly? Is threatening us women on TikTok? What? I'm still trying to figure out the whole.
What he does.
Do you know what? Okay, so remember the other day when they were driving around to go see his daughter, right, with the bags in the back and Brie going in the seat.
Mm-hmm.
Yeah, his daughter lives in Texas.
Yeah.
How are they supposedly in California but driving down the street to go see him? And now while
it's an old video, because people are assuming that whenever in the court docs where it said that Bree wasn't there for whenever the police came, people were assuming that that's the same time that they saw the daughter.
Oh, okay. Because I just thought out, I was like, wait, what's happening? So why all of a sudden now is he wanting to call CPS on?
Oh yeah, I saw that. I don't know. I saw the.
Yeah, no idea. Thank you guys for the 1.1 million likes.
But remember, did they get the stepdad fired?
Oh, I don't know.
Because I remember them saying that they had something on the stepdad and he was gonna lose his job. So it's weird that now they're trying to call CPS. Like,
they're a mess. They're down so bad. They just want everybody else down bad with them. Just be thankful and let your kids flourish. Your kids are doing great without you. His daughter now has apparently a great stepdad. Let them flourish. Baby W is doing great. Let him flourish. Y'all have your own seed created. I don't know who's going to take care of it when it's born, but shit. I guess she'll figure it out. Let that baby flourish too. I don't know. The whole thing is crazy to me.
It's so weird to think like this is somebody's real life.
I know.
Like, it feels like a movie sometimes. I'm like, dang, that's crazy. She also said
I was
the
thinking,
doctor confirmed her concerns about W.
yeah, she made a statement that said that she talked to the doctor and the doctor confirmed her concerns. So I was like, wait, what doctor? But then when I read through it, the doctor didn't confirm her concerns. The doctor said, if you have a concern about that and want us to test him, we can look at doing a referral, something along those lines. But no. And then she said that John lied on his 18-month thing, but you weren't there. You don't, how would you know? And not only that, again, you're not with the child all of the time. How you don't know what the child is like on a regular basis, day to day, And again, when the child doesn't know you, yeah, the child's not going to communicate. I gave the example. I just happen to have a granddaughter who is 1 month and like 4 days or some 3-4 days younger than baby W. She babbles because that's what they do at this age. She's 20 months. She babbles. She says
think
words.
Like Bree just hasn't been around a baby to understand. Like,
yeah,
he's not even 2 yet. What do you expect?
I don't know if she's thinking, if he's like, oh, well, last night for dinner I had blah, 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 right?
I had some hot dogs and chicken nuggets.
They don't talk like that. Yeah, so Jordan, like, she babbles, but she says words and we know what she's saying. But then, like, say, the rest of the family comes around that she knows, she loves, she sees often, but not as often. Yeah, she doesn't say as much. That doesn't mean that she's delayed or there's anything wrong. That's just how kids do.
Right.
Bree, your child doesn't know you. You're a stranger. Stranger danger. Stay away. Yeah, okay, there's nothing. You need to get an evaluation, Bree, not baby W.
I think that's the only thing that she's trying to like bring to court against 2K. Like, oh, she has this concern about W and it's not being addressed. But the thing is, like, he has addressed it, and if the pediatrician felt a different way, they would have referred him somewhere else. But the fact that you're constantly like, when are you going to make an appointment? You're going to make an appointment tomorrow. Do I need to make the appointment tomorrow? Like, girl, are you going to go to the appointment too? Because
exactly. You haven't been to none of the rest of them. It's so annoying. Mm-mm-mm.
She says she's
it is
to make
crazy.
The child father look bad when he literally does everything. Yeah.
No, she's looking bad all on her. She don't need no help. She couldn't make 2K look bad if she wanted to.
My sister's a doctor, like PhD, and the way she responds to things. Oh yeah, and then the difference between the lawyers on how they talk.
Oh, I know.
Like, I love 2K's filing. It be small.
Oh, me too.
Straight to the point.
Yeah, Taylor.
Ooh, we taking a trip. We gonna make it though, but we taking a trip.
Yeah. So I just told him, I'm like, okay, here's 2K's Taylor's response. It says, I am not going back and forth with you via an email. We will discuss this in court, blah, 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 litigate it, da, da, da. And then here's Lindsay's response, 4 pages. I'm like, for fucking sake, I'm here all night. I'm never eating. It's so annoying. But listen, we just got to get through April. Once it's transferred to Texas doesn't release, we should be good.
Yeah. But I just wanted to come say, hey, I heard you were on and tell you that
I appreciate it. Yep, I'm about to get off. Oh, I love watching you too, girl. I'm about to finally go make me some dinner because tomorrow my granddaughter got a basketball game in the morning. The grandson got 2 in the afternoon, honey.
Oh, in the
all right. Yeah, we got 3 basketball games tomorrow.
All right, I'm gonna let you get to.
Then I'll be back live. All right. Love you bunches. Thank you. Bye, girl.
How do we leave?
Oh, hold on.
Bye.
Oh, wait a minute. Oh, wait, I didn't figure it out. Hold on. Check taught me. All right, bye. Love you, girl. Yay. Wait, go look at what? All I see is Angie, go look. Oh, I love basketball. And I felt so bad last week. My granddaughter got confused. She had told me she didn't have a basketball game, and she did, and I missed it, and I was very sad. Oh, Bree's downfall page. Okay, I'll do that, and then I'll go make something. I don't want anything too heavy now, though. You know, like just something light. Okay, breathe. Oh, I thought what the fuck just happened to my brain? I thought someone told me that they lost their page. I'm glad it's still up. Okay. Which one am I looking at? The last one? This one? Oh, they deactivated night. Okay. About the San Antonio police report. I gotta be careful because they always play music. And I can't put it up on YT if I have music. Hold on. This is 4 days ago. I don't see anything about the police report. I don't see anything on his story. Heard someone got an eviction notice. Yeah, there's nothing there. You'd have to send it to me. So, do you respond to DMs? Respond to... Yeah, if I see him, I do respond to him as much as I can. Now I get a lot of them, so, but I do my best. I don't know. I just read it on there. Why? It seems like I'm getting darker. All right, guys, I'm gonna head out because I am absolutely starving. You guys are freaking amazing. There's still 1.2K people in here. It is 11:30 almost my time. We've been on here since 6:30. That is 5 hours. Okay. That's craziness. I love you guys so much. We got 1.1 million likes. Everyone stretch out your fingers. Listen, you guys are freaking the best. I so appreciate you guys so much. Get some sleep. I'll be back on live tomorrow, but it'll either be early, like in between games, unless we do a family lunch, or it'll be late. It'll be after my grandson's last game, I think is actually it'll probably be my normal time. So I just want to let you know I'll be live, but I'll put it in there. Thanks for hanging out so long. I am going to download this tonight. It'll probably be up in the morning, but I'll try to get it up tonight over there. So I love you all so much. Have a great night, and thanks for making this live so amazing. Love you guys. Bye.